May I permit to mention a matter for inclusion in my lord's list?
What is the matter? Hearing?
No, my lord, in the motion.
Yes.
With your lordship's leave, may be permitted to
Review
mention
that
an application in connection with the first appeal in a matrimonial matter. It's a
Application?
application,
Yes.
section 20.
I am mentioning the application for
Please.
Lordship, I am permitted to mentioning the matrimonial hearing.
Hearing we are not taking up now. We have added sufficient. Sorry. Call.
Item number 1.
Yes, Chatur.
Number 1, kindly make it short password, Mr. Pass.
Mention, why is it appearance to be mentioned?
Milord, they are hard pressing the contempt, Milord, application. They are pressing. State has preferred this appeal. So, Milord, we indicated our difficulty, Milord. Your Lordship said, Milord, the matter may appear as a to be mentioned, Milord. Lordship will consider the application for stay.
No, please repeat that.
Milord, they are hard pressing the contempt application before the
that's
single
the
judge.
urgency of it.
That's the reason, Milord, we indicated our difficulty before the
Could
court.
have appeared as an application.
Should have appeared, could have appeared, Milord.
When the interim order extended.
Section 5 was allowed.
No.
That is the first
It's a delay of 9 days, Milord. First time this
You
matter.
have Section 5 and granted stay.
Only make it short password.
You are proceeding with the contempt.
No. I want to say some
Milord,
fact, my lord. I am generally not opposed in the section 5. But in this matter, what happened? I said, only give me 1 minute, my lord. Only 1 minute. But in this matter,
Let us let the matter be moved. Yes, what is the ground, Mr.
Milord, ground for the delay.
Yes, for that.
Milord, ground is, Milord, in the process of getting approval, Milord, there's a mere 9 days delay. My lord will appreciate that.
You are the state.
I am the state, Milord.
Yes, what do you say, Mr. Basu?
Delay. Up to my
Your Honor, Junior was saying something.
delay, my lord.
But then you are not following instruction.
Junior, my lord, insists me to canvass this part. I will say no.
Heard learned counsel for the parties, full-stop, in view of sufficient explanation for the delay of about 8 days being explained sufficiently, can one of the 25 is allowed, thereby condoning the delay in preferring MAT 1329 of 2025. Full-stop, next para, in view of the extreme urgency pleaded by the appellant, the the connected application for stay is taken up.
Milord, may I please sit before Lordship?
So, Basu, please take your seat. We'll just hear him. And we are
Look-
taking up the stay application, although it's appearing under to be mentioned.
Because the interim order already extended is pending. No affidavit filed.
No, we need it.
Just
Milord.
done sufficient damage now. Let it.
Milord, may I place a list of dates? Milord, I'll take my lords to the impugned order. Milord, before that, Milord, the facts needs to be narrated for 2 minutes. My lord, kindly.
Interim order has been granted by the impugned order.
Milord, we have suspended the license pending inquiry. That has been stated.
Oh.
So, Milord, it is
License for?
Milord, the writ petitioner is a MR dealer. Milord, is a marginal ration shop dealer, Milord.
Yes.
Milord, we have inspected his shop on 4th of April 2025. Milord, we have found, Milord, kindly take my list of dates, Milord.
Yes.
Milord, we have found serious discrepancies. Milord, my lord, I can take your lordship to the charges. I will kindly come to paragraph 3, page 6 of the writ petition, where I have pointed out the charges before your lordship, Milord. Milord, 3, paragraph 3, Milord, page 6 of the writ petition. For my lord's convenience, Milord, I have quoted the charges in the show cause. Page 6, Milord, paragraph 3.
Page
Of
6.
page 6 of the stay application. I'm sorry, my lord. I'm sorry, my lord.
You're saying writ petition, that's why you are
I'm
looking
sorry.
for-
I'm sorry.
Yes.
Apologies, my lord.
Page
Page-
6, para 3. Yes.
My lord. Lord, it says, my lord, 4th of April 2025, the inspection was done. My lord, kindly see the charges. A, at the time of inspection, it was found that the FPS opening schedule was not displayed properly, which is contravention of such and such Control Order 2024. At the time of inspection, the scale cam board was not displayed, which is again contravention of clause such and such of Control Order 2024. At the time of inspection, it was found that few articles other than the PDS items were found to be stored and sold in the shop premises, which is in contravention to Control Order such and such. But only kindly note the year 2024. Milord, at the time of inspection, it was found that the accused MR dealer was doing transaction 50 meters away from the FPS shop, but delivering PDS good commodities from government approved godown, which transpires that he did not perform Duare ration properly, which is in contravention to clause 17 of the control order 2024 as well as order dated such and such. During inspection, it was found that MR dealer was not giving EPOS generated cash memos to the beneficiaries, which is again in contravention to clause 16.1611 of the control order 2024. During inspection, number of beneficiaries opined that the accused MR dealer did not distribute PDS.
There were serious allegations
No,
of integrity.
I'll read.
We have seen the others also
right,
weight, the weighing may.
Weight and Millard, your lordship has seen the G and H, your lordship will kindly take
Yes,
note.
those are more, those are very
True,
serious.
true, very serious.
Weighing machine and all.
But under such circumstances, Millard, we on inspection we found these discrepancies. Millard, my lord will kindly come to page 52. This is the show cause.
They had challenged the show cause or suspension.
They have challenged the suspension, which comes with the
All right, all right.
along with the show cause.
Simultaneously, right.
Simultaneous. Millard, this is the show cause come
Suspension
suspension.
till
7 days, till the proceedings reply is sought for and till the proceedings is concluded or earlier, Millard, the suspension will remain. Last but 3 paragraphs, Millard, I'll read.
yes.
It prima facie appears that you have contravened conditions stipulated in para such and such of the control order 2013. Millard, this is my mistake. Your lordship, in the charges
2024 and
2024. This Millard records to 2013. This is my mistake. And Millard, I say you are hereby put on under suspension immediately with effect till further orders. Millard, kindly again, Millard, take my list of dates. Millard, he immediately responds, not immediately, this is dated 23rd. He was to answer within 7 days. Millard, on 30th, Millard, he responds to my letter. Millard, will kindly come to page 54.
pointing out that difficulty, that error.
Right.
And you
Millard,
should have.
and Millard, he accepts that the proceedings is under 2024 order. Millard, will kindly see the 4th line, page 54. Pursuant to an inspection head on such and such, you have been issued a memo under which you have alleged some irregularities. FPS dealership also directed us to file a reply.
It says that there is no provision for suspension.
Millard, may I read it further? It appeared that by the said memo, you have
That
also
you have read,
suspended.
you have read, Mr. Chair.
So he has taken note of that.
He has taken a point that there is no provision for suspension.
No, I'll show that. I'll show that.
So there is a provision. You see.
There is a provision and the repetition is not on that. That there is no provision.
All right.
This is a
So let us see the impugned order.
for formal reply.
Let us see the impugned.
1 minute, Millard, to the list of dates before that.
All right.
And
Yes.
kindly, Millard.
Yes.
Millard, this is on 30th. On 5th again, Millard, he writes for extension of time.
By
Millard,
show cause.
to file the reply. To
Reply.
file the reply. On 23rd, Millard, we give a reminder that please submit your reply. On Millard 24th, page 58, 24th May, Millard, he writes that I am not able in a position to file the reply. Kindly allow me any time after 2nd of June. May I, Millard?
We are reading.
Kindly
Read
allow-
actually the entire thing.
Right, Millard. Millard, on 27th, Millard. Oh, on 3rd, Millard, the hearing was scheduled accordingly. The hearing was scheduled on 3rd June.
Read the entire thing.
Yeah.
So the hearing was given. Hearing took place.
Given, Millard. And Millard, finally, the representative, because the representative,
The consent to ignore inadvertence was not in writing.
not in writing.
It's your
Millard,
contention.
it is in our file. It is in writing.
In writing.
In writing in our file. But we deem it fit, Millard, my officers deem it fit not to rule out any, Millard, difficulties or contradictions on this, Millard.
All right.
Millard, further, same thing, no additional charges. I will kindly come to page 72. This captions as a modified show cause but is nothing but a reiteration of my earlier show cause.
But you give a go by to the previous one
But I have not,
in continuation of
in
that.
continuation. Right. My lord, I have held that the suspension order, page 75, my lord will kindly see, will remain in force in terms of the previous suspension order dated 23rd May 2025. This was, my lord, my modified show cause served on them. But this was challenged. This was challenged on two scores. Firstly, my lord, they say that the initial show cause is pending. This second show cause, my lord, or the modified second show cause, in fact, is a bad statement, my lord. The modified show cause is nothing, no addition, no alteration, but merely, my lord, see the last portion where I have spelled out 2013 order, that, my lord, we have sought to correct it as 2024. Now, my lord, on two scores, my lord, the petition was filed. Firstly, my lord, there is no provision for a second show cause or a modified show cause. Because my first show cause is already pending, you cannot issue a show cause, second show cause or a modified show cause. Secondly, my lord, they take this point that clause 50 of the 2024 order, my lord, mandates that the proceedings has to be concluded within 60 days. And, my lord, it can be extended to 90 days, which the learned judge has noted but did not rely upon on recording of reasons. My lord, kindly, they say, my lord, because of afflux of time, this show cause has lapsed. The court failed to take note of the later part of clause 50, which says that it can be extended up to a period of 90 days if the reasons are provided for so. But my first prime contention is, my lord, it is they, my lord, who has prayed for time. They have prayed for time for fixation of matter on 6th June 2025. My lord, one cannot play hot and cold, my lord. One cannot approve it and reprove it at the same time, as we have learned from your lordship. I will take your lordship to the impugned order. Page 80, my lord. May I read it for your lordship, my lord? In spite of service, nobody appears on behalf of the state authority. Petitioner are a partnership firm carrying on business of MR dealer through the license issued by the subdivisional controller, food and supply, Alipur Sadar. Petitioners were served with a show cause notice dated 23rd April 2025. By such show cause, several discrepancies were found during inspection by the competent authority, and the license of the petitioner was put to suspension with immediate effect further orders. The petitioners replied to such show cause. In terms of the reply, one hearing was conducted at the office of the concerned authority on June 10, 2025. It is the contention of the petitioner that the hearing of the concerned authority has not decided the issue by passing any order, but they again issued a modified show cause notice cum suspension letter dated June 17, 2025, wherein it has been mentioned that FPS dealership of the petitioner will remain suspended as per order of dated April 23rd, 2025. That is the earlier show cause cum suspension order. Mr. Basu, senior counsel appearing for behalf of the petitioner, submits that authority concerned, without deciding the fate of earlier show cause, cannot again issue a modified show cause cum suspension letter. Law does not permit respondent authority.
An arguable issue has been raised before the court. Arguable, it's arguable. Because not only of this 50 subsection 2, that's one ground. That may be a bad ground that you had the power to do it subsequently in writing, upon giving reasons in writing. It may be arguable whether that in writing can be done at the final disposal of the show cause. But the other ground is also there, that you issue a suspension notice, right? Suspension notice comes show cause. A hearing is conducted. After that, you are changing the goalposts, changing the rules of the game. By issuing a modified show cause, modifying the earlier show cause on which a hearing has been done.
I will appreciate this. There is no change. my lord, your
So
lordship.
then you don't press the modified
I
show
will not press it, my lord.
So then the
the-
order is correct. It has been stated.
Even if it has been said, my lord, on what parameters, my lord will kindly consider.
It is an arguable question. Mr. Chatterjee, we don't interfere generally with ad interim orders, particularly in a
my
writ
lord will
petition where
kindly-
some arguable issue has been raised.
My lord, I will deepest of respect, my lord.
If this is a final disposal, we
My
should
lord,
have.
with the deepest of respect, my lord, I say, my lord, I have orders of the Honorable Supreme Court which says, my lord, if you're dealing with ration card, ration food grains,
Understood, but
grains, my lord,
here we are dealing
you are
with the
dealing
request-
with public at large. 19(1)(g) will be superseded by the interest of
You
public
issue-
at large.
you,
My lord, we
you,
have.
nobody prevents you from waiving your earlier both the notices and giving a fresh show cause and suspension. Who prevents you?
Your lordship will.
Bypassing this? Or don't
Milord,
take a
the
leave before the
90,
court and
90 days is apparent, Milord. Even if I, Milord,
90 days is not the only ground. But
it is not only, but my lord will appreciate the second show cause is nothing but a retaliation of the first show cause.
after giving a hearing, whether you can do it, it's doubtful. If hearing was not held, prior to hearing, you gave the modified show cause and then gave a hearing, we could have understood. Show cause issued, they point out a mistake, hearing held. Here, after that, you issue a modified show cause, which is elaborate in nature, thereby changing the structure of the earliest show cause. Earlier show cause was very cryptic. So you change the entire structure. This is a new show cause for all practical purposes.
No, my lord, it is not cryptic. Earliest show cause.
You say right there only that it's a modified show cause, but it's for all practical purposes a new show cause.
It is all practical purpose. It is exactly the same show cause, my lord. Only difference I have
Where
failed
did you
to,
issue it then?
my lord, I have failed to make you.
You changed the 2013 to 2024.
Only that. The charges,
that was a faulty
charges,
show
my lord,
cause.
the charges in the.
No
Hello,
interference at the attitude.
kindly allow me 1 minute of time. Kindly allow me.
We've allowed it 5 minutes. 10 minutes.
Your lordship is really gracious, my lord. Your lordship
1 minute more.
my lord will appreciate the charges were spelled out under the 2024. Say, there's no question of prejudice in the first show cause. In the first show cause also, my lord, the charges, my lord will see are spelled out under the 2024 order. So there's no change, my lord.
You give us the pages again, Mr. Chatterjee.
My lord will kindly come.
First show cause and
First show cause is, my lord, page 52.
yes, 52.
All, my lord will kindly see it's 2024 from the
And the second show cause page
72, my lord. It
Yes.
is retaliation of the same, my lord. Except but one, my lord, 2024 order at the 7th line, 2013 has been changed to 2024. Exactly same, my lord. I've taken instructions on this. My lord, only difference is, my lord, will kindly come to page 52. 7th line, my lord, from the bottom, my lord, it records under 2013, that is changed to 2024. My lord, what will happen, my lord, will kindly see. The control order, my lord, mandates initiation of proceedings within a certain period of time. Now, my lord, these people will go scot-free. Why I say this, my lord? I will kindly take the control order.
So that we understand. That we understand.
These people will go for, ideally, my lord, I should have issued a corrigendum saying, please read the 7th line 2013 as 2024. This should have been the ideal course. I will kindly take this control order 50.
We are not going to the merits of the show cause.
No, my lord, the order, my lord, will kindly appreciate.
The time frame that has been quoted in the impugned order.
It is quoted. It is quoted, my lord, but the first part will, my lord, render the proceedings infructuous. Because I cannot today start a new proceedings. Your lordship will allow, kindly appreciate the nomenclature of the second show cause is retaliation of the first show cause. Nothing but 2023, not in the charges, in the concluding paragraph, one place, my lord, it has been changed to 2024. Nothing more, nothing less. Otherwise, my lord will, if your lordship are not, my lord, impressed with my submissions, my lord will kindly give us something that I can prosecute against a wrongdoer, my lord.
Give a go by to both and issue a fresh.
Then, my lord, today, again, my lord, for
The writ petition also from here.
that liberty, my lord, will give us, we'll do the, we'll do the, দাঁড়াও না, আমাকে বলতে দাও না, এরকম comment করছো কেন? Kindly see the inspection report, first part of it. Or the team shall submit its report to the licensing authority within 21 days from the date of inspection or visit. However, the report may be submitted within 30 days. Lord, today I am to conclude, I'll read, I'm sorry, Lord. 30 days from the inspection or visit in special circumstances and reasons for such delay shall be recorded in the report. All the proceedings initiated under the chapter shall be disposed of by the licensing authority within 60 days of the date of inspection. Inspection is of 4th April. Or visit. However, the case shall be disposed of.
The inspection preceded the show cause.
Of course, my lord.
So
On inspection, we found the discrepancies.
you have also failed that 90 days timeline.
No, it is not failed.
When was the date of the inspection?
4th April.
Yes.
I have 90 days.
That
When-
ends in, say, around 1st of July.
That does not, well, at least that will
When was the second, the modified show cause notice
17th,
of July?
17 June.
That was within that period.
Well, 17 June, within that date.
Well, we are not deciding the writ petition sufficient. Since we are here, we are having
But
to
again,
hearing.
my lord will appreciate, my lord will appreciate the state did not appear.
We can record a line that will not interfere. But this does not preclude you from initiating a fresh proceeding.
Well, today, if I initiate a fresh proceedings, the first bottleneck will be that the 90 days has passed. Initial, my lord, inspection is of 4th April. We cannot do it. He'll go scot-free. And for nothing. My lord, I would have appreciated all the charges in the first show cause has spelled out 2013. It is not so. My lord,
So the first line says 2024.
24.
Yes,
My lord,
yes.
every charge, not only the first one, my lord will kindly pardon me for saying this, my lord, every charge spells out 2024. My lord, 30th he responds that yes, under the 2024, so he's conscious, his action is waiving.
But we'll be disposing of the writ petition then if you hold those things.
Well, my lord will kindly,
It's a difficult-
then my lord asks the writ petition to be heard out because state was not, my lord will appreciate this, state did not appear. The fault of the state did not appear. My lord will kindly direct the first court to hear out the writ petition for the purpose of stay. My lord, noting that this occasion has arisen. My lord,
You have filed your opposition there
no, my lord.
because you have challenged. But challenge does not mean that you could not file your.
I could certainly file, my lord.
Given some time,
Lord,
3 weeks time, you did not file your objection or opposition
My
also.
lord, immediately I have come in appeal, my lord.
The notice of contempt was filed, my lord, this appeal.
Let us hear Mr. Basu. Yes, Mr. Basu, the ground is that.
May I place one judgment of this Honorable Supreme Court?
Yes. So you are hearing the appeal for all practical purposes. Yes, which paragraph? Give the
Lord,
citation for Mr. Basu.
This is 1982, my lord, 1 SCC, page 31. Lord,
Paragraph?
Here, my lord, the
Any paragraph?
paragraph, my lord, 6 onwards, my lord, I'll read for your lordship, my lord.
right.
Lord, here what has happened, my lord, initially the show cause was issued where there was no provision for suspension. Subsequently, my lord, the government has brought in an amendment wherein a provision was introduced, whereby, my lord, the show cause could have, my lord, the suspension could have been done without hearing the my lord, parties. Well, this was challenged that this is arbitrary to 19(1)(g) and 301 of the Constitution, as it renders 19(1)(g) infractuous. My lord will kindly come to my lord. I'll directly take your lordship.
Chatterjee, we are not hearing the writ petition on merits.
Then my lord will
Interpretation is very
kindly appreciate this. Today, my lord,
addressing the merits of the writ petition itself.
90 days I have time, my lord. When they
Not so palpably perverse or arbitrary the impugned order that
it
we
could
should.
not have, my lord, stayed, my lord, at the very out. The impugned, I say, my lord, the show cause is also not so palpably bad. Not so bad that it has to be stayed malafide, my lord will
That
kindly,
state nothing will remain in the writ petition.
my lord will kindly take note. The Honorable First Court notes that there is a malafide attempt on the part of the respondent. It is not so, my lord. He has responded to our show cause.
Where? Malafide?
Impugned order, my lord will kindly come to
Yes.
81.
Yes, malafide and illegal.
I mean, the Honorable First Court records that, my lord, you have records the provision that it can be done within 90 days. What says, my lord, it quotes the division bench, my lord, where the proceedings lapse within 60 days. 2013, my lord, there is no provision of extension. The division bench, my lord, quoted herein was on 2013. Where the completely this judgment of the division bench is not applicable at all, because this was under the 2013 Act.
2013, there was no provision for this.
No provision for extension. Today, Millard, these people, for Millard, this mistake of the state of not issuing a corrigendum. And your lordship has held the law that nomenclature should not matter, does not matter when it comes to justice.
Am I still bad? Which did not complete the proceeding at the judgment like 2013. Shall resume the supply.
I have video recordings to show that today the system is very upgraded. The ePOS machine is connected to the weighing machine. And when the person
negative order, discount order, if it is perhaps তার মধ্যে হয়তো করে ফেলি এটা কাজ করে ফেলি জারি করে ফেলি
Millard, may I please only
this judgment
one paragraph may I please of this judgment, Millard?
malafide paragraph
Para 9, Millard.
of this judgment.
Of this judgment. Millard, the power of suspension conferred by the second proviso, we also have a similar proviso, is by way of an interim measure pending the holding of an inquiry as to whether there is any breach which must result in cancellation of the license. It is true that suspension of license is a drastic measure if taken without affording the dealer a reasonable opportunity of stating his case. But it is a measure for social control in the interest of community. I say the learned First Court has interfered here. This is the question of prejudice. The power of suspension is necessary concomitant of the power to grant a privilege of license. By reason of clause such and such of order, no dealer can engage in business of purchase and sale of food grains except under in accordance with the terms and conditions of the license issued by the licensing authority in this behalf. The dealers are free to carry on their trade and business in food grains subject to their complying with the terms and conditions of their license and the provisions of the control order. But if they commit breach, they must face the consequences, and their license may be cancelled, suspended under such and such clause. They must face the further consequence of suspension of their license during the pendency or in contemplation of the proceedings for cancellation of the license. If the breach is of a nature that it must result in cancellation of a license. As already stated, power of suspension is a necessary adjunct of the power of grant of license in view of acute
So here
shortage
the
of.
second proviso was challenged, where unbridled
True.
power
Well,
was given
here,
without
it is not even challenged. So stand on a much
better.
for the ends of equity. I have video recordings which I can.
That we can add this. Definitely.
He has put on weighing measures on the.
So your allegations are very palpable. Let us hear Mr. Basu. Yes, Mr. Basu.
I have nothing more to say, my lord. What my lord has observed.
No,
Yeah,
that
but-
observation is now changed.
No, but this observation is my submission also. I say that's why I say.
No,
What
but
happened?
blanket fashion, here the effect would be the gravity of the
Maybe,
stay order
my
would
lord,
be
kindly,
huge.
I
There
am-
are serious allegations against you.
Well, allegations are
You
there.
will be able to continue the business.
Allegations are there. Well, kindly see this judgment just now showed to your
So
lordship.
the ground on which it has been set aside, stayed, Mr. Basu. First of all, clause 20 gives them a power to do it after within 90 days, and they gave the
Kindly
modification.
see the language there.
Yes, what is the language?
Kindly see the language in the control order. It
Yes,
has
give-
to spell. Kindly see this
Give
judgment.
the
my lord.
reasons. Give the reasons.
What is the reason?
Reasons not
Has
at
to
this
be spelled
stage.
out. My lord, your lordship knows very well. It is not in your file.
Then it will come
All
when
the
the order will
proceedings
come.
initiated under this chapter shall be disposed of by the licensing
This
authority.
is the
within-
mandate.
However, the
Exception is
case
there.
shall be disposed of within 90 days of the date of inspection or visit in special circumstances.
Yes.
Reasons for the delay shall be recorded in writing and in the when disposing of the matter,
No.
not in the show cause notice.
Suspension. So 60 days is previously.
Suspension is a necessary concomitant as held.
That I'm saying. Can you rely on that judgment? I am also
So
relying
the
on that
stay
judgment.
order, the effect of the stay order will be that you will be free to do whatever you're doing.
My lord will see the consequence of the statute. What statute says. But previously there was no suspension.
No.
Like my lord, service matters in contemplation of a proceeding, you will be suspended.
Now it is there.
No, now it is inbuilt that keeping in mind that is a serious nature, that's why a time limit of 60 days has been earmarked. And in exceptional circumstances, with reason, it can be extended for 90 days. Now, let us see what is there. Why this second so cause? Why court will not say malafide? I have relied on the judgment of your lordships for the apex court. It said beyond 60 days, you cannot keep any word person suspended.
2013
Now-
তার judgment.
এবার কি হবে?
একবার একটা fault.
Yes.
Now, my lord, your lordship court has said if beyond 60 days, you cannot suspend for any reason. But all suspension, my lord, proceedings must have been initiated, must have been there with allegation.
So now it is 90 days if they give reasons at the time of disposal.
Reason has to be given.
At the time of disposal, before that, where is the scope of reason?
Kindly see.
Where
you-
will they give the reason?
the orders, next order, suspension?
There is no order.
Yes, there is an order. So, my lord, kindly see the orders of so cause notice. Oh, before that, my lord, kindly count to 61,
60.
60.
Yes.
My lord, kindly see the date. Dara. 27 May 2025.
Yes.
Reference. 3rd April 2025. This is first suspension.
23rd April.
Yes. 23rd April 2025.
Yes.
Now, what is asking for? As per the rules, such and such, with as per the rules and guidelines, the proceeding decision and the discharge such and such has to be completed within 4th June 2025. That is within 60 days. That is their own letter. On, can you see the date? 27 May. This letter, my lord, subsequent so whatever name it is called, the second so cause or reiteration, only for the purpose of keeping the suspense and continue.
They can do it up to 90 days provided they give reasons subsequent.
Listen. Can you see the order of the second? What they have said that you are
This is
suspended?
not the final disposal of the show cause.
Not disposal.
This is
What
a
is
modification of the previous.
suspending
They
me.
only changed 2013 to 2024.
What I'm
And
sub-
that premises of the learned single
What-
judge is not, also not
what
correct.
I am submitting, my lord, kindly
2013, it was 2013, only 2024 written all through.
not necessary, my lord. Even when the date is the vital thing. Even if it is there to 2003 control
have
order,
the-
does
they-
not matter.
Under 50 subsection 2, they have the right. Sub rule 2, they have the right to extend it to 90 days.
Spelled out. But kindly see the second show cause notice, where
Spent-
I've been,
Spelled out not in the second, this is
Well,
not the second show cause notice. They say in the show cause notice is a modification of that.
well, kindly that.
And they start with in continuation and partial modification. That is, it's a modification of the previous show cause.
Has been made.
Only the date has been changed, nothing new.
No, everything has been, on many things has been changed, I am not on that.
Show us one change, everything is same. We initially had that impression.
If everything is changed, not changed,
2024 only.
not necessary, my lord, kindly visualize. It's a court of law, it is necessary to say, the incident happened in 2024.
If they give a go by to here and now, they give a go by to the modified show cause notice, then the entire writ petition will become infructuous.
No.
That is the only ground.
Suspension will go.
No,
No.
suspension first. No,
90 days they have right.
Kindly see the first show cause notice also. Kindly allow me to read with my lord, the first show cause notice.
আমি কোড দিয়েছি
Because the effect, Mr. Chatterjee is correct on that. The effect would be huge on the public.
My lord, maybe.
If you are guilty, if you are not guilty, then it's all right. But till you are,
Listen,
but till it is decided, you should be suspended.
kindly. First show cause notice.
52 is the first.
52
Well, kindly come to page 52.
Yes.
Well, kindly come to page 52, last line. We are concerned with the last line.
Yes.
Therefore, in the interest of the benefit of PJ such and such, you are hereby such and such till disposal of the proceedings or till further order. Proceeding was hearing concluded on 10th June 2024. Hearing concluded. Can you take a note of that? And in Bernard, that should, sorry, Bernard, my learned friend has correct me. Here also it is said is that in terms of 2024 control order.
That is what we are saying.
So this so-called,
So therefore, the only non-mention of
my lord, the second so-called notice only to extend
না না
because 2024 is here. So it is known to everybody that proceeding is continuing in terms of 2024 control order.
So this will not have the effect of extending if otherwise it is lapsed.
I am submitting, my lord. On 12th June 2024, hearing concluded. We have concluded the submission. And 17th June, so-called second so-called notice. Could have been disposed of, hearing concluded.
Another 60 days have been given here.
Yes, has to be.
নো নো কোথায় গেল? আমি বলিনি যে আওয়ার টাইম
That does not extend the original. They say it's a modification.
My lord, if it is modified, then again, my lord, 60 days lapsed. Only 30 days.
90 days. 90 days is the outer limit.
Language here.
90 days is the outer limit.
Kindly come to page 76.
Yes.
Therefore, you are hereby directed to show cause as to why not suitable.
76.
Yes, 75, last line. Therefore, show cause as to why no suitable action will be taken against you in terms of 2024 control order and all subsequent amendments, and you must submit reply or not before such and such, failing which an expert decision may be taken against you. Here it is also to mention that your PDF dealership will remain on suspension as per order dated 23rd April 2025. That is up to 60 days.
80 days.
From that date,
Melody will also appreciate it is who has been
শেষ করুন।
paying for time.
I repeat, my lord, pardon me for repeating. Hearing concluded on 10th June 2024. Judgment could have been delivered within that period. Only to keep him revived, my lord. That's why, my lord, I don't know what is particular Honorable Single Judge's mind. He said malafide.
That's all. Mr. Chatterjee, if it was a modification, then why give another opportunity by extending thereby extending the time?
Milord,
It could have only been a modification. The show cause notice remains the same. As we earlier asked you, after the hearing is over, how can you give a fresh direction to give another reply to show cause? This is a new notice.
again, Milord, this was an opportunity Milord will appreciate. This was an opportunity to them. Otherwise, they could have come today, Milord, come with the texture of the petition would have been little different. That I could have submitted my reply. I did not.
It's
This is
absolutely arguable, Mr. Chatterjee. this
If it is
new
argu-
opportunity
if
to
it is
file a reply.
arguable, my lord, but
You treat it to be
I
spell out modified,
at
but to
the-
give them another opportunity, treat it to
with
be a new reply.
deepest of humbleness, deepest of humbleness, my lord, I say, my lord, if it is arguable, I am entitled to, my lord, suspend them. If it is arguable, because this effect is on
If
public.
it is arguable, therefore,
If-
then stay should be granted to protect the writ petition from becoming infectious.
Today, my lord, everything goes, I cannot conclude these proceedings. My lord, will kindly see. Again, today, my lord,
On the basis of this show cause as modified, no, you cannot conclude.
my lord, the suspension will remain in terms of the previous only, as stated.
একটা order record করো।
My lord, will kindly give me
At the
leave.
time of hearing the application, comma, we find from the tenor of the arguments made by learned counsel at length that in effect, comma, the issues involved in the appeal itself have been urged. Accordingly, we dispose of the appeal along with the application. So next para, learned counsel appearing for the state submits that the impugned order suffers from patent legal error on several counts. It is submitted that the learned single judge placed reliance on a judgment to come to his findings, comma, which was rendered in the context of the 2013 control orders, which did not have a provision similar to Rule 50 within bracket 2 of the 2024 control order, comma, which permits the authorities to extend the time of disposal of a proceeding for termination of license beyond 60 days up to a limit of 90 days, comma, subject to recording reasons. Next para, learned counsel further contends
Once may
that the premise of the impugned order was also that the act of the
one thing.
respondent authorities was malafide and illegal. Learned counsel submits that there is no basis for such
May I
finding.
once, my lord, interfere, my lord.
Next para. Learned counsel places reliance on the provisions of sub-rule 2 of clause 50 of the control order, which provides that all the proceedings initiated under the said chapter shall be disposed of by the licensing authority within 60 days of the date of inspection or visit. However, comma, the case shall be disposed of within 90 days of the date of inspection or visit. In special circumstances and reasons for such delay shall be recorded in writing. Next para, learned counsel for the state stroke appellant next contends that the subsequent show cause notice dated June 17, 2025 is merely a modification of the first show cause notice dated April 23, 2025. Next para, from the language of the second show cause notice, comma, it is evident that it is in continuation and partial modification with the earlier one. Learned counsel further points out that the only change effected in the second show cause notice, bracket a modified show cause notice, bracket closed, is that whereas in the third last paragraph of the earlier notice, comma, the control order of 2013 had been erroneously mentioned, comma, the said mistake has been rectified in the subsequent show cause notice. Next para, it is also argued that the first show cause notice all through refers to the control order of 2024 and as such, comma, was otherwise valid in the eye of law. Next para, learned counsel contends that by way of the second show cause notice dated June 17, 2025, comma, the earlier one was only sought to be modified and the latter cannot be construed to be a fresh show cause notice. Next para, learned counsel for the petitioner for the appellant places reliance on the judgment of such and such reported at 1982 1 SCC 31, where it was held in connection with a similar statute that it is true that the suspension of license is a drastic measure if taken without affording the dealer a reasonable opportunity of stating his case, comma, but it is a measure of social control in the interests of the community. Full stop. The Supreme Court further held that it seeks to strike a proper balance between the freedom of trade or business guaranteed under Article 19 within bracket 1 within bracket small g and the social control permitted by clause 6 within bracket of Article 19 of the Constitution. For some next para, learned counsel submits that in the present case, comma, the appellants are placed on a better footing than in the case involved in the cited judgment, inasmuch as clause 50 within bracket 2 specifically provides that upon giving reasons, comma, which can only be given at the disposal, comma, the time limit of 60 days for disposal can be extended up to 90 days. For some next para, learned senior counsel appearing for the respondent submits that the subsequent notice, comma, although captioned to be a modified show cause notice, comma, affords a fresh opportunity for filing reply, comma, thereby seeking to extend the stipulation of 60 days.
Yeah, interfere once.
Dehors the law. Full stop next para. It is further pointed out that the hearing in terms of the earlier show cause notice dated April 23, 2025 was concluded on June 10, 2024.
Here, my lord,
Full stop. As such, comma, there is no scope of further direction, so further opportunity being given to the respondents to give another reply to the said show cause notice. Full stop next para. We find from the impugned order that the learned single judge proceeded on the premise that the proceedings initiated by the show cause notice was to be concluded within 60 days from the date of inspection. Full stop next para. However, comma, the learned single judge also considered the effect of clause 50 within bracket 2, comma, which was quoted in the impugned order. Full stop next para. By itself, comma, the non-completion of the proceeding within 60 days cannot vitiate the notice and perhaps could not have furnished a valid ground for staying the impugned order, comma, impugned notice, comma, particularly keeping in view the social context, comma, having larger ramifications for the greater interests of the community at large. Full stop next para. However, comma, we find from the subsequent show cause notice dated June 17, 2025 that in the same comma, a fresh opportunity to give reply within June 23, 2025 was given. Full stop next para.
I will kindly.
Prima facie, comma, if the second show cause notice was merely intended to be a modification of the earlier notice, comma, there could not be any possible opportunity for giving a further reply after the hearing was already concluded on June 10, 2024, that is prior to the subsequent show cause notice dated June 17, 2025.
Will kindly allow me 1 minute. Kindly, my lord. I'm very conscious that I'm troubling the court. Will kindly. Let on 10th, when they appear, they say they have concluded. On 10th, my lord, they appear and they agree to let go this inadvertence. On 11th, page 68, my lord, will find they have written a letter. But this was the reason of providing that opportunity. On 10th, appear, my lord, they say the hearing concluded. We have records which show that they have accepted that yes, 20 will consider this to be 2024. On the next day, 11th June, they write to us that please do not, we are pressurized for this, please do not insist on that our consent. This was the reason at page 68, we will find.
Next. Learned counsel for the appellants have taken a further point comma, in a bid to justify the opportunity in the second notice for filing of reply, comma, that the respondents had raised an issue that the consent given by the respondents, one respondent, two,
Two of them.
that the respondents,
Partnership form 4.
কি বললাম? In the hearing dated June 10, 2024, to the extent that the error in quoting the 2013 control order in the show cause notice dated April 23, 2025 was given a go by, comma, which was sought to be challenged by a subsequent letter by the respondents, comma, disputing such consent having given by them.
In
Full
fact,
stop.
it says, my lord, they have signed it.
When Madam is reading that, can you read the entire
Next
letter?
para. At this juncture, comma, it would be premature for us to go into the merits or veracity of such allegations of the respondents or the defense of the appellants against the same. Full stop. However, comma, even if such a dispute was raised by the respondents to the effect that they had never conceded to the discrepancy of the year of the control order, comma, the same ipso facto does not justify the issuance of a fresh notice or a fresh opportunity being given for filing a reply. Full stop. Next para. It was for the appellant authorities to deal with the objection raised by the respondents while disposing of the proceeding initiated in terms of the original show cause notice dated April 23, 2025, comma, if necessary, dealing adequately with the allegation of the signature of the respondents being taken by force. Full stop. However, comma, merely because such objection was raised by the respondents does not give the power to the authorities to issue a fresh show cause notice, comma, granting a fresh opportunity of reply to the respondents, comma, which prima facie belies the contention of the appellant authorities that the subsequent notice was merely in the nature of a modification of the allegations made in the earlier one. Push up next para. We are conscious that we are taking up an appeal against an ad interim order, and even the writ court has not yet disposed of the writ petition, but merely directed affidavits. Full stop. Thus, comma, we make it abundantly clear that the observations made above are only of a prima facie nature, comma, being tentative and shall not influence the learned single judge while disposing of the writ petition in any manner whatsoever adverse to the interest and contentions of either of the parties. Push up. However, comma, in view of the above discussions, comma, we find sufficient reasons for the impugned order of stay having been granted by the learned single judge. Push up. Next para. Moreover, comma, in an intra-court appeal, comma, unless there is a palpable perversity or error of law going to the root of the order, comma, there is in normal course, comma, no interference by the appellate bench. Full stop. Keeping such test in mind, comma, we find that such high yardstick has not been met by the appellants in the present case. Full stop. Accordingly, there is no scope of interference in the appeal. Hence, MAT 1329 of 2025 along with Can 2 of 2025 are dismissed on contest without any order as to cost. Full stop. In view of the nature of the allegations leveled against the respondents, comma, it is we request the learned single judge to make endeavor to dispose of the writ petition as early as the business of the learned single judge permits.
We are extremely grateful, my lord. I'm extremely sorry that I interjected the court, my lord.
You never do it. Why did you do that?
This will not, someone will go scot-free.
Just because your client is
No, my lord, it is not
poking you.
so. Not so, my lord. I am able
You don't have to prove it. You are beyond the stage of proving anything to your client.
Certainly, not that, my lord. I was
You personally are beyond that stage.
I personally, my lord, was feeling little aggrieved that these people will go scot-free. That is the reason, not to impress my client, my lord.
Next man.
Extremely grateful, my lord.
Yes.
Item number 2 and item number 3, it concerns same suit schedule of property, my lord. This is the affidavit of service, my lord. Few have returned back, but before the tribunal also proceeded against them, my lord, passed an order, my lord. This writ petition relates to, my lord, the rejection of my section 5 application.
No, all have not been served.
Few have returned back, my lord, but
They contested in the court.
in tribunal also proceeded ex parte, my lord. They did not appear before the tribunal, my lord.
But tribunal must have been satisfied regarding service. We cannot proceed ex parte without being satisfied on the service. Just because tribunal proceeded ex parte does not mean that they were not served. Unless they are served, we cannot take up ex parte matters. How can we? Their interest will be affected, obviously. Who are they? Those people?
My lord, they are the
This-
legal heirs of the deceased person who preferred an appeal before the BL and LRO. I informed the appellate
They
authority.
won the appeal.
My lord.
They won the appeal.
My dead person won the appeal, my lord. At the time passing of order, all the appellants were dead. I have informed that particularly to the appellate authority that persons are dead.
That was
Under
the
that-
ground for challenging the tribunal.
No, my lord, that was the grant for one of the ground for condoning my delay in preferring the appeal. After informing the appellate authority that the persons are dead,
You are appealing for whom?
No, we are, my lord,
You are together.
represent the.
So none of the private respondents, you are for the private respondent. None of the private respondents, their interests will not be
There are
represented.
two matters, 2 and 3 are same.
my lord, palpably illegal dead persons appeal.
No, we
That
don't
is on
know.
merit, but
We
section
don't know
5
without hearing the other side. The alive persons should be heard before holding that it was in the name of it.
Served, my lord.
Yeah.
So maximum
all
respondent,
the
private
appellants
respondent
were
have
not
been
dead.
served, my lord.
Who have not been served?
all the appellants were not dead.
My lord,
Who have not been served? Which ones?
my lord, one Ruthin Sardar returned back.
Give us the numbers.
That
You should have come prepared with a chart of on who has not been served. You are enjoying any interim order?
my lord.
You are enjoying any interim order?
No, section 5 application was rejected by the tribunal. There was a delay of
What?
438 days, my lord. That has been tribunal has held that there is no.
But this will affect the rights of the respondents. They were present when they were served, but
They were served, but no one appeared before the tribunal as well.
how many have not been served?
My
Look at
lord,
the
4 to 5 respondents, my lord. 9, 4, then
The appeal was preferred by their predecessor.
my lord.
The appeal was preferred by their predecessor, which was
They were
allowed.
dead at the time of passing the order.
You say that, we don't know. Without hearing them, how can you?
That is on record. I have death certificate. I have annexed the death certificate as well.
Before us.
Yes, my lord.
Then
One of the appellant that was who was dead at the time of passing the order. My lord, I informed the appellate authority that the persons were dead. Thereafter, I was under the reasonable impression that the appeal would have been dropped.
Achha, these persons were served at the address where you have served now, sent
Yes,
now.
my lord. Yes, same address. Same address. Few returned back as addressee left. And one refused, my lord. I have the one
Oh, yeah,
consignment
this is served.
that is refused,
Very ill. What is the matter?
my lord. My lord, the 2 writ petition concerns same suit schedule of property, my lord. Because there are
দেখান বুঝাই তো যাচ্ছে দুটো একসঙ্গে পরের ফাইলটা দিয়ে রাখো
my lord, may I proceed?
Section 5 was allowed why? No expansion.
Rejected.
Sorry, rejected why? No
My
expansion.
lord, may I place the
No
improvement?
expansion of day-to-day delay.
Yes,
That
my
is
lord.
not a problem.
That is the reason why the learned tribunal has rejected my section
Only
5.
let us see your section 5 first.
Yes, my lord. Section 5 is at page number, my lord. If my lord is
167
one
starts.
You are very thorough, Mr. Gali.
160, 160 onwards, it starts.
ঠিক আছে, but averment start from 167.
Yes. 167, and reasons has been stated. I have pleaded the reason in paragraph 5 onwards, my lord.
What is your age? Senior citizen means?
My lord, reason is one of the reason is that the
Age.
my lord,
Age.
is above 60. Above 60, I'm a retired person, my lord.
Above 60 is nothing.
Above 60, my lord.
Above 60 is senior citizen.
Above
You are senior
70, my
citizen
lord.
for the purpose of railway tickets and other things.
Above 60.
But you don't lose your, mobility and everything.
The reasons are,
Above 60, but half of the judges then would be ineligible.
my lord, age does not, my lord,
Age is a number.
it's very
You
good
have,
to
you
everyone,
have
my lord.
given serious.
My lord,
No,
I have
you're not
other,
bothered with.
other
You're not
reasons as
bothered
well.
with that.
I have other
But-
reasons as
But
well.
senior citizen, if he was 80 or something like that, we could understand.
My lord, I have other,
Senior citizen of India being a layman is not capable of understanding the legal constitution.
my lord, I have other reasons as well, my lord.
What is the reason? Let us see. We are at page 168.
Yes.
Those are the reasons.
5, my lord, then 6. Paragraph number 6. No, 5. I have some grounds in 5 as well. My lord, after the skip over the age factor, my lord, it is imperative, my lord, last 4 lines.
Hmm.
It is imperative to mention herein that the appellant on 8/8/2021 at around 12 p.m. received one of the notice of hearing sent by the additional district magistrate and district land and land reform officer, South Chowbish Pargana, wherein it was stated that hearing of LR appeal case preferred by the private respondent is scheduled to be taken up for hearing on 8/7/2021, but due to shortage of time, the appellant cannot attend the hearing
On
of
8/8/21, you received a notice for a hearing of 8/7.
8/7, my lord. That is typography error. That should have been 8/7.
Both are 8/7.
Yes, 8/7, my lord. Finding no other alternative, wrote a letter on 12.
You have not even put any signature beside the corrections.
My lord, since it was filed, my lord, that point of time, my
If
lord,
this was filed, then this should not have been looked into by the
that
tribunal.
is on
Rightly
record, my lord.
rejected.
I have annexures as well, supporting my typographical error, my lord. That is inadvertent, my lord.
So you got
That
a
should have been
notice, but
7.
on the same day.
Yes, my lord. My lord, thereafter, the said appeal pursuant to the order of ADM and DLRO, South Chowbish Pargana, the RI Block Land and Land Reform Officer Sonarpur conducted a physical inquiry about the suit schedule property, and the appellant being in possession over the suit property showed all documents to the concerned officer and also informed him that most of the appellant in the LR appeal are dead. The appellant, after informing such fact, he was under the impression that the case would be dropped as the appeal cannot be heard out at the behest of the dead person. It was
This appeal was preferred against what? It was mutated in your name.
Yes, since concerning same suitable property, my lord, there were 2 mutation proceedings, one in favor of my mother, other in favor of me, my lord. That was challenged by the appellant.
That's why 2 appeals.
2 appeals, my lord. In the interregnum period, my mother gifted me the property. I have become the sole owner. My name was recorded in the LR with respect to 10 katas.
So why two separate?
But since there were 2 mutation proceedings, 2 appeal, 2 orders, my lord, that's why I have to prefer, my lord, 2 original application as well, out of which this writ petitions emanates, my lord. My lord, paragraph 7, the appellant with an expectation that the copy of the said order would be served. This is one of the reason, my lord. Other reason that copy of the order was never served upon me. After informing the appellate authority, I was under the impression that the appeal would be dropped or necessary steps would be taken for substituting the deceased person. That was not done. My lord, in spite of doing that, my lord, the appeal was disposed of. That order was never
You have
communicated to
annexed
me.
those death certificate before us also.
Yes, one of the death certificate I have, that is my father, who was the appellant in that, added as a party in the appeal as well.
Added as a party. There were other appellants also.
Other appellants also, they were also dead. My lord, the name of the appellants would be apparent at page number, my lord, 110. My lord, kindly take up 110 first, then I'll show the death certificate, my lord. 110, my lord, this is the death certificate itself, my lord. My lord, kindly see Bhadreshwar Noskor, who and tallies it with page number 143, my lord. 143, my lord, and tallies the death certificate. My lord, Bhadreshwar Noskor, appellant number 2 at page number 143. My lord, his death certificate 110. My lord, he died in the year 2011. Order is
No, but
approved.
your basic reason is that you appeared in the appeal and pointed out.
Yes.
But then you were under the impression that it would be dropped, and you did
Not
not take
necessary. My lord,
any information for after 400 something days.
mm,
You waited for the
My
appeal
lord,
to be dropped.
my lord,
And what was your expectation? It would be served on you automatically.
no, my lord, the appellant would be.
You should have
substituted.
appeared in support of your letter or whatever you have
My
written.
lord, I've informed the authority, my lord. Thereafter, my lord, I was absent on that of the final. That is categorically recorded.
on a particular day you are absent,
Yes,
on
my lord.
8th of July.
Yes, my lord.
Subsequently, on
Receive
12th of
notice, I don't dispute.
Subsequently, on 12th of July, you appeared before the appellate authority. You gave a letter in the form of a letter.
Yes.
You have said
Yes.
that these people are dead. Then you don't take any information and don't participate in the hearing
Man, even-
and don't stand by your letter that say, yes, these are the death certificates. Simply giving a letter, how will the appellate authority know that letter is correct? You have to appear on the next date and give the death certificates to the appellate authority. Otherwise, how would it know?
My lord, I was under bona fide impression.
What
that
bona fide intention?
that
It's
the
absolutely malafide intention.
appeal cannot continue against the dead persons, my lord.
You no, it can very well can, because the death was not established by you before the appellate authority. How will it be known to the appellate authority that you are speaking the truth?
I cannot.
You write a letter that they have died and but you are gone. 400 something days after 1 year and some days you come up.
I cannot improve.
You
over
cannot
that.
file an appeal at any point of time.
That
No.
remains, my lord. But however, my lord, the order was never communicated to me. After
Is there any statutory compulsion on the authority to communicate
No.
to you?
There is no.
Unlike the Arbitration Act.
But I have judgment to show that it is the duty where right when my right is affected, that is the duty of the quasi judicial authority to inform me about the order,
Shows that judge.
my lord. Harassment. देखिए এটা বের করো না 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 my lord, give me a moment, my lord.
Yes.
My lord, I'm relying upon AIR 1961 Supreme Court, page 1500, my lord. I'm handing over the copy, my lord. 1500, my lord. My lord, paragraph number 11. My lord, the principle has been relied upon by the Honorable Supreme Court, my lord. Paragraph number 11, my lord. My lord, may I read, my lord? A similar question arose before the Madras High Court in unnormalized such and such case. Section 25 of Madras Boundary Act 28 of 1960 limited the time within which a suit may be brought to set aside the decision of settlement officer to 2 months from the date of award. And so the question arose as when the time would begin to run. The High Court held that the time can begin to run only from the date on which the decision is communicated to the parties. If there was any decision at all in the sense of the act, says that judgment, it could not date earlier than the date of the communication of it to the parties. Otherwise, they might be barred by their right to appeal without any knowledge of the decision having been passed. Adopting the same principle, a similar construction has been placed by the Madras High Court in such and such case on that limitation provisions containing in section 73(1), 77(1) of the Indian Registration Act 16 of 1908. It was held that in a case where an order was not passed in presence of the parties or after notice to them of the date when the order would be passed, the expression within 30 days after making of the order used in the said section means within 30 days after the date on which the communication of the order reached the parties affected by it. This decision shows that where the right of the parties are affected by any order and limitation is prescribed for enforcement of the remedy by the person aggrieved against the said order by reference to making the said order, the making of this, my lord, I have missed the line, the making of the order must mean either actual or constructive communication of the said order to the parties concerned. Therefore, we are satisfied that the High Court of Allahabad was urged in coming to a conclusion that the application made by the applicant in the present proceedings was barred under the provision of section 18 of the Act, my lord.
In paragraph 7, it is recorded that in this connection, it is material to recall the fact that under section 12(2), it is obligatory on the collector to give immediate notice of the award to the persons interested. In that context, it was held. Here, there is no obligation at all. And secondly, you participated in the proceeding. You are aware of the proceeding. It's not a case that benefit cannot be extended to you.
My lord, whether that, subject to correction, my lord, correction, whether that order survives, my lord, it's a nullity in itself, my lord. Order
That is the only question which is disturbing us.
Goes to the root of the case, my lord.
That is the only question which is disturbing us.
Can that proceed, my lord? Thereafter, I have communicated with my learned advocate. But the time taken by the learned advocate to prepare the draft and file the same. This was the other limb of reasons as pleaded by me in the
Mr. Gali,
application.
other grounds, yes, we are not so satisfied with Mr. Naik's arguments, but yes, it's a nullity. Should the
No, my lord, My lord,
It is, because before us also some death certificates have been annexed.
my lord, in
If they were
respectful,
dead actually.
in respectful reply to the honorable court's my lord query, my lord. My lord, my respectful submission, all the appellants, my lord, were not dead. There were, my lord, surviving, my lord, appellants. Secondly, my lordship knows, my lord, better than us, my lord, that what my learned friend has argued, that till the completion of argument, they were alive. At the time of passing judgment, they were dead.
No,
This is what he said.
no. 2011, one person.
I don't, what he said, I gathered it from his submission.
No, he has annexed a death certificate
I've never
at
submitted.
page
that.
110.
My lord, death certificate at 110 years.
What is the date of that? Death?
2011,
And this order was passed out?
2021.
Then
No, but all the, lordship, that is on the merit of the case.
no merit, not merit only. If somebody was dead,
Nullity, if an order is passed against a dead person, it's nullity to the extent of that particular person, not in respect of other persons. Lordship, my lord, I should not, my lord, at the cost of castigation, submit this proposition at least before this honorable court. So, my lord, now here, my lord, the question is that which were the, my lord, appellants were alive, who were dead.
they have annexed one death certificate only.
Lordship, and my lord, kindly seize, my lord, the order sheets of the appellate authority, my lord. All
Appeared.
through, he has been telling, kindly seize, my lord, page 14. He never appeared, he never said. Kindly seize his conduct in the appellate proceeding. He never said. He just take a ground in the section 5 application that I informed the authority, all these are dead. Why are you not taking note of these? Then I was under the impression.
But from the order sheet, it is evident that they never appeared.
Never. Kindly seize, my lord, page 140 onward, just 4 pages. Kindly seize 4 pages. Order sheet number 1 onwards, my lord, this my learned friend has annexed to his writ petition. 140, order number 1, kindly seize. Whereas it appears the appellant filed under section so and so, so and so. DA is asked to notice to all concerned, that is order sheet number 1. Now, second order, appellant is found present. Nobody is found present on behalf of the respondent. He is the respondent in the appeal. Then comes, my lord, next order, 8 July. My lord, 141.
My lord, can you take up page 179?
This what is there?
So now
I
he
have
says
informed the authority.
impression.
Received by the authority itself, my lord. There is a stamp, my lord, in the
83.
179 in my first writ petition. I read WPLRT 138 of 2005.
And 83 notice, kindly see the notice given on appeal, my lord, page 83. It is said that Jugal Kishore is since deceased.
My lord, this,
The notice which was served by us is at page 83.
my lord, subject to correction, my lord, all the appellants were dead, my lord. This is my categorical appointment in the
You have annexed only one death certificate.
one death. I have one death certificate with me, but I do not have the other death petition. My
How
lord,
do you know the others are dead?
my lord, they are dead. As per instruction of my client, my lord, they are dead. My lord, kindly take up 179 once. I have informed the authority before the passing of the order. My lord, apropos your letter number such and such, I do hereby convey my request to your honor in regards to the facts that RL and of BLRO South Chobbish Pargana Sonarpur Kolkata came to my house on 28/4/2022 verification of the above case when I brought to the knowledge of the RI that the Jugal Kishore Noskar has passed away on
20th September, received date.
2022. One of the appellant was dead in the year 2021. Thereafter, however, I produced all the documents relating to the above case for verification satisfaction.
When was the award passed?
It was passed on 20th September, on the day he gives this particular representation.
But that was
But that
received.
to that he never.
That was on record.
That when it was given might be at 5 o'clock, but never did he bother to appear and participate in the proceeding and say this.
Who contested on behalf of the dead person, my lord? If the persons are dead, who
The
contested?
respondent should have come and say this.
The present appeal arises out of an order passed by the learned tribunal, learned Land Reforms and Tenancy Tribunal, whereby the application for condonation of delay in preferring an original application against the order of an appellate authority, whereby the mutation in the name of the present appellants were set aside. Appellant and his mother were set aside. For sub next para, both the writ petitions arise out of two mutation cases in respect of connected proceedings and as such are taken up together for hearing. For sub next para, learned counsel for the petitioner argues that the order of the appellate authority which was challenged before the tribunal was passed in the name of dead persons, comma, since all the appellants were dead at the time when the order was passed by the appellate authority. Full stop. Learned counsel places reliance on the death certificate of one of the appellants, comma, which has been annexed at page 110 of the present writ petition, which indicates that Bhadreshwar Noskar, comma, one of the appellants, met his demise on December 14, 2011, comma, that is much before the passing of the appellate authority's order. Full stop. Next para. Learned counsel places reliance on such and such reported at AIR 1961 SC 1500, where the Honorable Supreme Court held that Honorable Supreme Court relied on certain judgments of different high courts, where it was held that time can begin to run only from the date on which the decision is communicated to the parties, and that where an order was not passed in the presence of the parties or after notice to them of the date when the order would be passed, comma, the expression double inverted within 30 days after the making of the order, double inverted close, used in the in the statute under consideration means within 30 days after the date on which the communication of the order reached the parties affected by it. Full stop. It is thus submitted that in respect of proceedings before quasi-judicial authorities, comma, it is the incumbent duty of such authority, comma, if an adverse order is passed, comma, to communicate such order to the person against whom the order was passed. Full stop. Next para. Learned senior government advocate senior government advocate refutes the contention that all the appellants were dead at the time of passing of the order of the appellate authority. Full stop. It is submitted that even if one of the appellants was dead by then, comma, the other appellants were alive, and as such, the cause of action for preferring the appeal survived in the rest of the appellants, and the entire order of the appellate authority cannot be deemed to be a nullity. Full stop. Next para. Even as per the communication made on September 19, 2022, allegedly by the present appellant to the appellate authority, comma, one of the appellants, namely Jugal Kishore Noskar, had died on April 27, 2022. Full stop. It is submitted that as per the principles of the Code of Civil Procedure, comma, which ought to be adopted in the absence of any specific provision in the present case, comma, if a demise of one of the parties occurs after the hearing is concluded, comma, it will be deemed that the order is passed against such person, comma, creating a legal fiction that the person was alive at the relevant juncture. Full stop. Next para. It is further contended by learned senior government advocate that the present appellant, comma, despite having admittedly written a letter to the appellate authority, comma, chose not to appear before the appear in the appellate authority's proceedings repeatedly, which is borne out by the records of the appellate authority, comma, the order sheets of which have been annexed to the present writ petition. Full stop. Thus, comma, the principle laid down in the cited judgment does not apply in the present case. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we take note of the fact that only a single death certificate of one of the appellants before the appellate authority has been annexed to the present writ petition. Full stop. Thus, comma, it is not even clear till date as to whether the appellants, all the appellants before the appellate authority were deceased at the juncture when the appellate order was passed. Full stop. Next para. Surprisingly, comma, the appellant seeks to take shelter of a communication made on September 19, 2022, comma, that is after the hearing of the matter was over before the appellate authority, comma, indicating that one of the appellants had apparently died. Full stop. However, comma, it is admitted in the application under section of 5 of the Limitation Act, comma, which was which was filed before the tribunal, comma,
My lord, page 168 onwards.
that a notice of hearing of the appeal was served on the present appellant on July 8, 2021. Full stop. Although it is contended that the said date itself was fixed for the hearing and as such could not be attended by the appellant, comma, it is not clear before the court and remains unexplained as to what prevented the appellant from appearing in the appeal even thereafter. Full stop. Next para. Since the appellant, comma, in its application for condonation of delay before the tribunal categorically admitted having knowledge of the pendency of the appeal, comma, the reason for the absence of the appellant thereafter in support of his contention that the appellants had died is unclear. Full stop. Even in the communication dated September 19, 2022, comma, the death of only one of the appellants was mentioned, comma, which is quite contrary to the submission now made from the bar on behalf of the appellant that all the appellants were deceased at the time the appeal was disposed of. Full stop. Thus, comma, not only is the stand of the appellant contradictory, comma, since the death of one of the appellants was intimated to the appellate authority and the death certificate of another is produced before us, and the appellant chose deliberately, comma, despite admittedly having knowledge of the appeal at least from July 8, 2021, not to attend the hearing, comma, we do not find any error in the learned tribunal having dismissed the application for condonation of delay of the appellant. Full stop. Next para. On a more basic premise, comma, it can only be held that an order is a nullity if all the appellants were dead at the time the same was passed. Full stop. Even if it is arguable as to whether the right to sue survived on the other appellants, comma, it would not be a case where the order passed would be a nullity ab initio. Full stop. Next para. In the present case, comma, even the factum of death of all the appellants has not been established till this court by the appellant. Full stop. Thus, comma, there is no question of the consideration of nullity of the appellate award which was challenged before the tribunal as a mitigating factor for the delay in preferring the challenge before the tribunal. Full stop. Thus, comma, we do not find any reason to interfere with the impugned order. Accordingly, WPLRT 138
And one.
of 2025 and WPLRT 141 of 2025 are dismissed on contest without any orders to cost. Full stop. The connected applications, comma, if any, stand disposed of accordingly.
My lord, kindly keeps my right open to approach the authority if available under the law, my lord, to
How can you approach the
my lord, I am the possession over the property. I will not be able to mutate my name, my lord.
next? Yes.
For the respondent, the review application opposite.
On behalf of the applicant, I'm saying,
Why?
he has done particular operation is done.
What? Some defect is there. But let us
We
see the
have
defect.
not provided with the copy since there is
In the certified copy, the name of respondent number 6 is Tanuja Bibi, but in the memo of appeal, wrong. The name has been typed erroneously. Respondent number 6.
that
You are the advocate on record.
And for the applicant, on behalf of the applicant, I'm saying,
Are you the advocate on record?
no. Our side of this applicant.
He is present in court.
Yes.
Advocate on record is present.
No. Conflict.
Oh, he himself could not come.
At the order 41 stage, my lord, your lordship dismissed the second appeal. Since no substantial question of law has been, my lord, framed, my lord, thereafter the review application is being preferred. So this defect, my lord, is in the appeal, then
No, defect is in the review application.
review application. Then only one thing, my lord, kindly fixes a date. Because the revenue authority, in spite of dismissal
So
of
we'll
this,
say that the pendency of this will not.
my lord, kindly do that. My lord, they are, my lord, citing the ground of this memorandum of review, they are playing adjournment.
An adjournment is sought on behalf of the review applicant on the ground of absence of the learned advocate for the applicant. Which of next para, we find from the report of the stamp reporter that there are several defects in the review application. Full stop. Leave is granted to the learned advocate on record for the review applicant to correct such defects in the memorandum of appeal within 2 weeks. Within 2 weeks from date. Within a fortnight from date. Full stop. Next para. On the prayer of the applicants, comma, let the matter stand adjourned till September 18, 2025, 2 weeks. Full stop. It is, comma, however, comma, made clear that pendency of the review application shall not be construed as a stay of the order of which review has been sought, and it will be open to the parties to proceed on the premise of the order under review.
But if they could provide me a copy, since I am appearing, my lord. I appeared, my lord, as a
A copy of the review application and the memo of the review application and the memo of review shall be served on the learned advocate on record appearing for the respondent. How soon can you do that? Is the file here? By September 12, 2025. Ask his clerk to give a copy within September 12.
I'm grateful.
Please give your name. Give your name.
Item number 5 has come up.
Five is not, perhaps, five is perhaps not the hearing of the appeal along with the application. So
Not today.
that was the order.
That's why not today.
Oh.
Yes, what is the matter?
Because
Yes.
well, this is my appeal. The
Could you release the other matters for the rest of the day? Mr.
Right.
Banerjee and Mr. Bhattacharya are appearing.
might,
Mr. Kaur is my leader.
Mr. Kaur is there. So
Then it may be cut short a bit.
he could be.
Since you are led by Mr. Banerjee, who will save the court from Mr. Banerjee?
सुनो ये जज साहब को बोला था 26
They will not save. Let him argue then. Mr. Banerjee, what is the matter?
No,
This came up before us previously.
once, my lord, on
it
the
has come
7th
up once.
on the 7th of August 2025, when your lordship was invited to the order under appeal on the ground of Mr. Banerjee, my lord, time was
No.
he was not there.
Before the
Audit so was
coordinate bench, this matter was taken up for consideration. Appeal and application have been directed to be heard together. 3 points. Each of the points are short, but the legal arguments on them might be slightly dilated. Blood. Points are these. The petitioners are Aeroheight Apartment Consultants Private
Mr.
Limited.
Banerjee will start after we come back after 10 minutes. We will come back in 5 minutes.
Yes.
26 चलो
Yes, Mr. Banerjee.
Certain lands, my lord, are purchased, my lord. I am for the appellant HIDCO. HIDCO was a private respondent in the writ petition. The writ petition was disposed of at the motion stage after calling for certain status reports without going into full-scale affidavits. In the writ petition, the honorable judge of the court, honorable single judge, was pleased to hold that because of the fiction in section 11A, there
Land
has
acquisition.
been lapse. There has been a lapse.
All right.
Now, on that premise, the writ petition was allowed, but what was sought to be avoided by the writ petitioners very discreetly and very cunningly was the writ petitioners, by that manner, wanted to avoid taking an NOC from the HIDCO, irrespective of the fact that the lands in question or part of the lands in question are within the planning area of HIDCO. My lord, in order to make, my lord, the submissions short, may I take your lordship, my lord, into the writ petition which is annexed, my lord, to the stay application. Please have a look at page 34. The writ petition starts. This is the case that they make out. Please come, my lord, to paragraph 3. I'll just jump paragraphs, only 3 lines of each paragraph or 4 or 5 paragraphs. All of your petitioners own different plots of land at Mauja Chapna within the territorial limits of Techno City. Petitioners are in occupation of such lands. Petitioners acquired title to such plots of land now owned by them upon purchasing such land under registered indentures in lieu of valuable consideration. Dates of indentures are not mentioned. I'll come to that later. So they have purchased. After purchasing, they have recorded their names as owners and possessors in the records maintained with the BL and LRO. They are, according to them, making regular and ritually payment of taxes, etc. Now, my lord, the entire table is given. Which writ petitioner has how much, my lord, ownership in respect of the lands in the concerned Mauja. Lordship, kindly see 20 writ petitioners, total land 168.85. Now, my lord, will kindly straight away come to paragraph 6.
Yes.
Upon, your petitioners state that in the recent past towards the beginning of 2023, your petitioners jointly took a decision to utilize the said plots of land by developing the same and setting up a residential complex. Petitioners did not have means or experience or expertise to undertake such development work, and therefore petitioners started approaching some developers who were ready and willing to develop a said plots of land. Now, it was in course of the process of development of the lands, that's in 2023, that it surfaced for the first time that the plots of land comprised in RS Dag number 39 and 43 and also portions of land comprised in RS and LR Dag numbers 37, 38, 44 and 45 at Mauja Chapna had allegedly been proposed to be acquired sometimes in 2005-2006 for the alleged purpose of setting up a township thereat by the name of New Township. Your petitioners could also somehow gather information that such township was intended to be set up by the respondent number 6 in alliance or collaboration with the respondent number 5. Kindly seize, my lord, the respondent number 6 is
5.
the HIDCO, that's us. Respondent number 5 is the West Bengal Housing Board.
Respondent number, yes.
6 is us, WB HIDCO.
Yes.
5 is Housing Board. Now, kindly comes, my lord. So in 2023, for the first time, they come to learn they have purchased several plots. Dates of purchase not mentioned, according to me, fatally so. But then I'll come to that later. In 2023, when they get that information, then, my lord, they get their hands in 2023 on certain papers. Kindly come to paragraph 7, page 52 of the stay application. Immediately upon receipt of such information as regards alleged initiation of a proceeding for acquisition of the lands comprised inter alia in RS Dag numbers 39 and 43 and also portions of land comprised in RS Dag numbers, LR Dag numbers 37, 38, 44, and 45 at Mauja Chapna, your petitioners conducted a thorough inquiry into the matter, and while conducting such inquiry, so this is in 2023, your petitioners could somehow lay their hands on several correspondence issued by the respondent authorities over the past several years. Your petitioners could also procure two several notifications published in the official gazette on 21st of January 2008 and 13th of February 2009 pertaining to the relevant land acquisition proceeding.
These are the section 4 and section 6 notices.
4 and section 6 notices. Now kindly come to paragraph 8. From a perusal of such gazette notifications that your petitioners could lay their hands on, transpired that as long back as on 2nd November 2007, a notification had been issued at the instance of the respondent authorities under section 4. So 2nd November 2007, section 4, indicating therein that the land comprised in so and so may be required to be acquired for public purpose. Under such notification, the provisions laid down under section 5A of the Land Acquisition Act 1894 were also sought to be dispensed with, invoking section 17 of the relevant statute. Please mark, my lord, we shall come to the statute.
Land
there.
acquisition.
So 17
Yes.
invoked. Please have a look at 17, my lord, while on this. Special powers in case of urgency.
Yes.
So 4 read with 17. My lord has by now seen, my lord, 4 read with 17. So 17 is invoked, 5A dispensed with. So regular acquisition procedure is not taking place. It's an urgent acquisition procedure. This is admitted by the petitioners in their own pleadings. Second thing of note is the petitioners come to know this from the public domain. They have not said that this was kept away from them by the respondent authorities and therefore they first had knowledge. So whatever knowledge they have now in para 7 is a part of their constructive notice which hit them prior to the sale. Doctrine of constructive notice, now it has been explained, has similar effects as the doctrine of actual notice. And whatever they say they have known in para 7 would be deemed to have been in their knowledge at every point of time, even prior to the sale. Because they don't say that it was kept away from them by some machination or the other, and they came to know under special circumstances. Constructive notice is there. Why this constructive notice comes into play, I'll also come later. Now, my lord has seen, my lord, 4. Now, my lord, kindly see. The petitioners challenge this section 17, invocation of section 17. Kindly see paragraph 9. What is their challenge? Petitioners respectfully submit that invocation of the emergency provision laid down under section 17 of the Act of 1894, para 9, 1894, at the instance of the respondent authorities as indicated above, was patently illegal and unwarranted in any view of the matter. Please see, this is a challenge to the 17. Challenge to the 17. Your petitioners state that section 17 had conferred an extraordinary power upon the respondent authorities for dispensation with the normal procedure laid down under 5A of the statute in exceptional cases of urgency. Your petitioners respectfully submit that such emergency power ought not to have been lightly resorted to by the respondent authorities, particularly when there was no real urgency requiring the lands intended to be acquired to be taken immediate possession of. Your petitioners state that setting up a township could never have been an emergent requirement that could have necessitated or justified dispensation with the procedure prescribed under section 5A of the Act of 1894. Challenge goes on, paragraph 10. Petitioners submit that by reason of the arbitrary, capricious, and random use of the emergency provision, the owners of the lands intended to be acquired were illegally deprived of their valuable fundamental and constitutional rights in relation to the respective immovable properties. Your petitioners state that while invoking such emergency provision, the respondent authorities also did not record any subjective satisfaction of the alleged need for invoking the emergency clause. Lock, stock, and barrel challenge to 17. Petitioners state that keeping in view the alleged purpose for which the relevant lands were intended to be acquired, the purpose behind such proposed acquisition would never have been frustrated or defeated had the landowners been provided with an opportunity of being heard and to raise objections as contemplated under section 5A of the statute. Your petitioners state that no urgency has also arisen at the relevant point of time suddenly or overnight. Your petitioners state that by invoking the emergency provision provided under Section 17 of the Act of 1894, the respondent authorities acted without due care and irresponsibly. Your petitioners also humbly submit that such invocation of the emergency provision by the respondent authorities in connection with the LA case of 23 of 2005-6 was completely without justification and also not sustainable in the teeth of the law laid down by the honorable courts. Petitioners humbly submit that the inquiry stipulated under 5A was not merely statutory, but also had a flavor of fundamental as well as several other constitution and legally enforceable rights. Petitioners state that since the respondent authorities had miserably failed to demonstrate any genuine subjective satisfaction justifying invocation of the emergency provision, the notification dated 2nd November 2007 was palpably bad in law. So 4 read with 17 is bad in law because invocation of 17 is bad. That's the challenge. The notification of paragraph 11, notification mentioned in the immediately preceding paragraphs was thereafter allegedly followed by a further notification on 12th of February 2008 and published in the official gazette on 13th of February 2009, whereby and whereunder a declaration inter alia in relation to the plots had been made under Section 6. Your petitioners, however, have not been able to lay their hands on any further or other document or notification demonstrating any further or subsequent progress made by the respondent authorities in relation to LA case number 4 of 23 of 2005-6, post publication of such declaration made under Section 6 of the Act. So this is the case. Now, my lord, kindly comes to paragraph 15 at page 57.
Yes.
Your petitioners state that to the knowledge of your petitioners, no step was ever taken by any of the respondent authorities in connection with LA case number 4 of 2324, 4 of 23 of 2005-6, post publication of the declaration made under Section 6 on 13th of February 2009. Your petitioners state that insofar as your petitioners have been able to ascertain, the respondent authorities stood idle over the matter after publication of the Gazette notification on 13th of February 2009 and took no further step in relation to or in connection with the said land acquisition proceeding. The plots of land allegedly intended to be acquired under LA case number 4/23 were also not demarcated, nor possession thereof was taken by the respondents from the erstwhile owners thereof, nor any notice was ever published to at least to the knowledge of your petitioners inviting any objection against the proposal.
Read the entire pleadings. So they take a point that no land subsequent proceedings were initiated.
Therefore,
first of all, they hit at the root of that Section 17 invocation because there was no urgency. Secondly, 11A. Because nothing was done after that and 2 years
11A.
elapsed.
Now, in their prayers, kindly come to the
Perhaps 17 also they invoke 11A.
Yes, no, I'm not taking your lordship to the entirety, but there is kindly now come to the prayers.
Yes.
Page 88.
Yes.
LA case number 4 of 23 referred to here and above be declared to have lapsed in terms of the provisions laid down under Section 11A of the Land Acquisition Act. Plots of land comprised in these dags be declared to be freehold land. That's paragraph B. Slightly iffish prayer before a writ court. Declaration be also made declaring that none of the respondents have any semblance of right or authority to cause any interference or obstruction in the peaceful utilization and enjoyment of the state plots owned by your petitioners. This is where, my lord, the actual game, if I might use that word with great respect to all concerned, is operation. In the garb of saying that there has been a lapse, the petitioners want the HIDCO and the Housing Board and statutory authorities to lay their hands off the land even in case of statutory compliances. And that's why this writ petition was occasioned by the fact when HIDCO wanted them to approach HIDCO to take a no objection.
But that statutory obligation, statutory whatever, comes only if HIDCO is it has been acquired and HIDCO is the...
Even otherwise, as a planning authority,
all right,
within the planning area, HIDCO has a role to play.
Even if it's not HIDCO's land.
Even if it's not HIDCO's land, number one. Number two,
yes,
your entire case of the petitioners is based on 17 being bad. If 17 is bad, then there is lapse under 11A, otherwise not. Please consider this. Please see 11A just once. 11A and its format. 11A is a fiction. These fictions can't be extended to any other situation. There cannot be any logic in fiction. Fiction addresses a particular situation.
No double fiction.
No double fiction, no penumbral fiction. Fiction hits it right on those facts. Present, fiction, yes. Not present, fiction, no. Please come to 11A.
Yes.
The collector shall make an award under section 11 within a period of 2 years from the date on the publication of the declaration. And if no award is made within that period, the entire proceedings for the acquisition of the land shall lapse, provided that in a case where the said declaration has been published before the commencement of the land source. Therefore, my lord, collector shall make an award under 11 within a period of 2 years from the date of publication of the declaration under 6. That's the mandate. In a 4 read with 17 situation, there is no 5A. There is no publication of award. There is a shortcut.
Yes.
So unless the 4 read with 17 situation is debunked at the instance of the petitioners, fiction of 11A cannot apply. You can't stretch that fiction like an elastic to fit this situation also. Lord, that's the fundamental point. Please test this point.
No, even if section 17 was not applicable,
let's say section 17 was not applicable, 4 comes,
then automatically
comes,
11A comes in.
The moment 6 comes and the
PRC
conditions don't come in, 2 years go, any time left in litigation added to it, super added to it, if that period is over,
yes.
award is not passed, goes.
What if 17 is applicable, then according to you?
Then, my lord, when 17A is applicable, then, my lord, how is the thing required to be seen?
Yes.
5A objections, my lord, are taken off. Please come to 17.
Yes.
Special powers.
Though no such award has been made on the expiration
can be taken off.
So, and shall thereupon vest absolutely.
So the 2 vesting dates are different.
Yes.
Everything is
all
different.
Previous requirements.
Yes. That's why they had to challenge, my lord, these 17 in order to succeed in a plea of 11A. Well, am I clear to you, Lord? They challenged the section 17 aspect of section 4, saying that the urgency which was shown in section 17 was arbitrary, it was unfounded, it was unreasonable, and therefore they challenged it in so many grounds because they knew full well that if 17 is attached to section 4, 11A doesn't come in.
Mr. Banerjee, we were wondering aloud, what prevents the state from resorting to 17 in every case? What is there? I mean, in every case, it can be said some emergency.
No, the executive discretion left by the legislature to the executive for the purpose of coming to a conclusion regarding the nature of urgency.
That urgency should also be justiciable.
Yes, but at whose instance and when? Who's coming to challenge it? In 2023, persons who are post section 4, section 6 notice transferees. And the effect of that is, by those persons not having challenged that at all, they can't lay a challenge at all. Supreme Court now calls them, they are persons who, as successors in title or claiming to be successors in title.
Purchase.
My lord,
when did they purchase?
This is the question, not given here. They have not mentioned it. It has been kept under wraps. They purchased it at a point of time when they would be hit by the consequences of that 4 and 6. 4 is 12 February 2008.
Yes.
6 is,
12 November.
4
is 2nd November 2007.
Sorry, I'm sorry.
6 is 12 February 2008.
2008.
Published
on 13 February 2000.
Yes. And purchases?
Purchases are not given.
They have produced any purchase deed before the writ code. Must have annexed something. Others, how do you know that they ever purchased?
Grave leave.
It was an ex parte order.
On contest.
On contest. So nothing was
calling upon reports on the authorities.
I showed the reports. I showed the reports. I'll show the reports. I'll show the reports. I'll show the reports.
Yes.
My lord, the purchases that they have made is not disclosed.
So your report does not say anything about those purchases.
The reports were, what is the stand of HITCO regarding the fact that NOC is required to be taken of them? HITCO said that there is a land acquisition proceeding which had been commenced, gives the number of the proceeding, says that we are not handling the proceeding, state is. Insofar as these lands are concerned, a part of the lands are within our planning area. Therefore, there would be requirement for our NOC. That's the HITCO's affidavit.
Do they challenge in the relief portion? They don't challenge the NOC requirement.
Kindly see.
They challenge the acquisition outright.
So they challenge the acquisition outright? No, that's what they're doing, not the acquisition outright. Please, see, Lord. They,
Yes.
it's for lapse. A.
Yes, the acquisition. They challenge the acquisition in the sense that there was no lapse.
According to them, acquisition lapse under
the acquisition, the section 4.6 culmination in it.
4.6 culmination.
They challenge that they said lapsed.
Fiction, lapsed. As a result of that lapse, perhaps that is what they want to contend. Prayer A is the principal relief. Prayer C.
Interference or obstruction, they
Prayer
can claim.
D.
They don't say that the compliances are not necessary, because if it's otherwise statutorily some compliance is required, then they don't pay for anything regarding that.
Kindly clarify that and the appeal is over. They can't go out of the realms of HITCO by saying.
So permit your petitions to continue to occupy D.
No, see, kindly D is dispossessing them, etc. That no HITCO can ever do.
This obviously subject to statutory rights which you have.
And that one of the statutory
or other statutory requirements which they have to comply.
They have to comply with. One of the requirements is to come to HITCO and see whether a part of it is within its planning area. If it is, to see whether they are in tune with the land use and development control plan of the area.
So your stand is that section 17 was invoked. There is nothing to show there was no urgency, or it's your discretion, and therefore there could not be any lapse.
There could not be any lapse under 11A.
11.
But the learned judge has held that there's a lapse under 11A at the instance of the state. Please have a look at the order. Order ball.
State and HITCO are at loggerheads.
State and HITCO are not at loggerheads. HITCO is showing the law, my lord, to the honorable court with respect. State
don't have that respect.
No, should have showed the law.
Only the law.
Should have showed the law. So something.
Mr. Banerjee is appealing for the state.
No. Something.
Don't get frightened. That's not a stigma. You are for the state. So one of them should actually give him a place. There is none else to. Yes, that's sufficient. You sit in the middle because your place is in the middle. Yes.
Should create a barrier.
Clients like counsel. Everyone needs a barrier, my lord, when I am there. Even Mr. Court does not give me his blessings when he's sitting across me at the bar.
No, my blessings will reach him despite the barrier.
So let us go to the impugned order once. Suppose we'll come back from there.
Yes, please see 228. I've shown you, given your lordship the background because your lordship now knows what are the elements.
Obviously.
Now please come to 228. That's the impugned order. Before that, 2 reports have been called. State has said that the proceeding has lapsed. And WB HITCO has said that there's a proceeding continuing. That proceeding we don't know up to what
Rajesh Upadhyay all the way. Whichever page you are opening, it's Rajesh Upadhyay. 4 pages still now. What
at
is happening in High Court?
One point of time, it was Rajesh Khanna, my lord. Rajesh Khanna, matinee idol.
Yes.
So this gentleman appears to be, my lord, the land and
covers the
property
mornings idol. Also, not only the matinee.
Evenings, mornings, etc.
Yes. What is happening in this court? Monopoly.
He should be named as a statutory authority after this. We should have Article 226 against him sometimes. All pervasive control. 220.
228.
228.
Right.
228, my lord. October 6, 2023. Heard learned counsel for the parties. And, my lord, there was, my lord, a veritable array of assistance, my lord, from the bar. The primary grievance of the petitioners is that the 6th respondent, that's me, has refused to issue no objection certificate in favor of the petitioners for raising construction in the plots in question for the reason that the plots were intended to be acquired by the state respondents and notification under section 6 of the Land Acquisition Act was published. Please have a look at the prayers.
But yes, this is not there in the Anyway,
Now,
we are
proceed.
indicating so that Mr. Kaur can answer on this.
Yes.
Obviously, yes.
Lord, next paragraph.
Hmm.
The state respondents have submitted a report in the form of affidavit, which demonstrates that though notices under sections 4 and 6 of the Act of 1894 were published, no award was passed within the stipulated time frame nor possession taken. In view of the above, the only inference that can be drawn is that LA case number 4 of 23 of 2005.
But admittedly, it was a section 17 scenario.
Yes. How does this come in? I'm asking myself. With such a lot of veritable assistance at the bar. In view of the above, the only inference that can be drawn is that LA case number 4 of 23 of 2005-6 lapsed in terms of the provisions laid down under section 11A of the Act of
This
1894.
could not be held unless section 17 challenge was upheld.
Yes, and that section 17 challenge was abandoned. Please have a look at the judgment from beginning to end. Read whatever my lord wants to read.
Abandoned in so many terms.
Abandoned. They did not press the fact that there was any section 17 urgency. Section 17 urgency was, my lord, a moonshine. It was something which was just created for the purpose of the proceeding. Nothing. It's not argued. The only thing argued is state comes and files a 2-page affidavit saying my proceeding has lapsed. State itself is giving a 4 read with 17A. State is coming and saying my proceeding has lapsed. WB Hitco is there, it files an affidavit saying I am no one to say whether the proceeding has lapsed, but I say that part of it is within my planning area, so you need to take NOC. Kindly see how the prayer is made before the court below. Is this the prayer in the writ? I'm asking myself. Kindly see, my lord, how the learned judge, my lord, in this case has been taken to a different train of thought altogether. Now, my lord, page 229, may I continue? In the result, first paragraph. So kindly see the result of the writ petition. In the result, the plots in question can be held to be freehold plots not covered by any acquisition. HIDCO being the sixth respondent herein, therefore cannot have any impediment in issuing no objection certificate in favor of the petitioners. Is the HIDCO a no object? Is the HIDCO saying that the land belongs to me?
Independent of the land acquisition, you have that.
And there is this, it's within the planning area.
And we'll also look into that regulation or rule which you have for no objection certificate.
Yes,
Have
yes.
that.
Yeah, I don't have it at present. I can show it from the Act. But there is automatically that. There's automatically that.
If an order is passed that you cannot insist upon a no objection, even if there is something in the statute, you cannot insist upon that.
So my hands are tied. And this becomes an order of the court. And no one is in cross appeal before your lordship. So no one says, the writ petitioners, they do not say that we had challenged 17 also, but that challenge was not recorded, entertained. If it was not recorded, then remedy was to go back before the self-same honorable judge. If the writ petitioners are aggrieved by the order, which they should have, because a different relief on different conspectors has been sought, then there at least ought to have been a cross appeal or a cross objection worth its name. No, the learned judge, in my reciprocal submission, with great respect to all concerned, has been sold a dummy, if one might use the expression. A different set of cause of action in the writ, a different cause of action here at the time of pleading. And this is not coming from novices.
Let us hear the seller.
Yes, my lord, there are two.
Seller of the dummy.
Just 2 points more. This writ petition on the face of it was not maintainable in view of a train of judgments of the Honorable Supreme Court. They say very clearly.
Why not maintainable?
A post Section 4, Section 6 transferee cannot have
Yes, was judgments on that.
challenge acquisition.
I'm not clear on that. I say I because I can speak for myself that I am not clear on that.
I mean, so
at least one judgment.
There are various. I'll show you, lordship, a few.
Post Section 4(6) transferees are not entitled to challenge the
acquisition or even plead lapse.
On the premise that their vendors have acquiesced.
Yes,
that is
yes,
the difference.
yes. Absolutely.
These are the judgments.
These are some of
we
the
rely on the principle.
Bhagwan.
Please see paragraph 3.
মুখ ফসকে বেরিয়ে গেছে।
দাঁড়ান, আমি এখন দিইনি, দাঁড়ান। Paragraph 3, my lord, of that note, page 2.
Paragraph 3 of note, short note sector. Ordinary idea of short note.
Law is now well settled. It would not be open to any transferee to challenge an acquisition or a purported lapse in acquisition, particularly in the event.
Mr. Basu is prepared with a copy.
Yes. He knew that this would come, especially when it's Mr. Upadhyay, my lord.
Oh, no, so very good. On that premise that the original owner did not challenge.
So you can't challenge. And that's why it was incumbent on them to say when they purchased. Everything they said, my lord, in tabulation form, every allegation they repeated
Except
twice.
the dates of the.
Except the dates of
So you have got hold of those transfer deeds.
Ms. Pechi.
No had disclosed nothing. Not in the writ petition.
Deeds crave
So,
leave.
Proceeding on the premise that they are post
Because otherwise, adverse
they
influence.
came to know.
Adverse influence.
No, they could have.
Came to know 2023.
No, came to know later on also. Even if they were.
This came to know doesn't help them. That is one. Now Supreme Court is very clear. Even earlier it was clear. There's nothing new which has been laid. Effect of constructive notice is as deadly as actual notice. Constructive notice and actual notice are similar in effect. If as diligent intending purchasers, you ought to have known this upon due diligence, then it will be deemed that you have knowledge of that. Your nonchalance will not come to your aid.
You should be pitted against Mr. Kollal Bosu all the time. Mr. Cod is no match for you.
Absolutely. And I
You don't
remember
consider.
the late
Nonsense takes us off our feet. I mean,
I remember the late
it's
Mr.
good that you have
Piju
understood what is nonsense because we know otherwise this omniscient and all this.
I more I see him, I remember Mr.
Mr. Piyush Datto, none else.
Fondly, Neki, fondly.
I
He didn't say
remember
he didn't say fondly. But
just I remember one matter.
Calendar of events.
I was asked to assist him. I was 6 months into the profession.
Oh,
And it was a cross-examination which was happening in the City Civil Court before the learned Chief Judge, the then Chief Judge. Now, first question objected to. Second question objected to. Third question objected to. The learned judge said, Mr. Dutt, if you keep on objecting, we can't proceed. At the end, after the examination in chief is over, then you put your objection. I will make a separate order. And he sat down, but before sitting down, he said, this is an admonition in, I'm forgetting that expression, something like that. The learned judge, he relaxed and he didn't know what to.
No. Obviously, that was the intention also, probably.
there's a new word doing.
We don't know whether here this was that was the intention, but
There's a new word which has been formulated, which goes on doing the rounds, which is actually not there.
He said expression was, sorry, I just remember, it's a crucifixion in Nazi Germany. then he sat down.
The swastik fell off it.
yes. What is going around?
Ostracism and castigation mixed together. Castracism is going on doing the rounds. Not the homophonic.
May have different
not
connotations.
not the homophonic indication.
It may have several.
It may have several. So castigation and
It is
ostracism.
very risky in some
Yes, in some cases, not
certain sensitive cases. It
get sensitive is the word.
difficult to use the.
Difficult to use. So, my lord, the nonchalance of at that particular point of time is as fatal as not having actual notice. So, the fact that his constructive notice theory is a doctrine of equity doesn't really make it less powerful. So, you ought to have known that there was an acquisition proceeding. You ought to have known that there was section 4 read with 17 because you came to know of that in 2023, not in special circumstances. I could have understood if the pleading said this was not aware in the public, this was not there in the public domain. I made searches before that. These are my search reports. This is my solicitor's search reports saying that nothing of that sort was there. I went to the authorities, nothing of that sort was there. But see, in 2023, I found that from a red box somewhere in the BLRO's office or from the State Land Acquisition Collector's office, these records have popped up from which I came to know. Then also, at least pleading wise, treating them to be true and correct, you have a case. Otherwise, public domain, finished. Constructive notice. So you've suppressed the fact that there was a notice under 4 and 6. Whether you could have purchased at all when a notice under section 4 is there is itself a vexed question. I'll place judgments on that also. But suppressing that you have purchased, kept quiet, hobnobbed with the authority. When the concerned authority having jurisdiction wants you to take an NOC because it's within its planning area, You file this writ petition. You challenge the section 17. Say that there couldn't have been urgency. First point, you couldn't have done that. 3, A to G, I've given your lordship judgments. Please be satisfied when I submit. Any one of them, my lord, can qualify as a qualifying judgment. May I take your lordship, for instance, at এইগুলো পেজগুলোকে এখানে দিসনি, এখানে লিখে দিতে তো।
Page 3 টা আমি লিখেছি।
Page 3 কোনটা লিখলি?
এই 92, 82, 88 দাঁড়া 82 দিকে দেখানো শুরু করো।
আচ্ছা, please come to page 82 just once. Just a few judgments on this.
82 of this compilation?
Yes.
দাদা এই কম্পাইলেশনটা কি একটা প্রপোজিশন?
না, অনেকগুলো proposition. I can understand what that was. Lord, kindly see, my lord,
82.
2022 10 SCC
see paragraph 12 to 14. Paragraph 13, in fact. Be that as it may, even considering the fact that the agreement to sell was of the year 2016, and considering the fact that the notification under section 4 of the 1894 Act was issued on 25th November 1980, therefore it is apparent that the original writ petitioner allegedly derived the interest in the lands in question much after the acquisition proceedings were initiated, and therefore respondent number 1 in the SLP, that is the original writ petitioner, can be said to be subsequent purchaser.
This is not actually because you are a subsequent purchaser, you cannot, but it's an extension of the principle of waiver.
What your predecessors have waived?
Attributable to the original owner also.
Absolutely.
So that's settled, that the principle of waiver comes in if there's a long delay and you, despite knowing you did not do anything.
And this
that applies to the original owners also.
Original owners also.
That it's an extension of that only.
Yes. So that has been taken forward, but engrafted into this branch of law by as many as 8 or 9 judges.
This branch of law, there are judgments that
Yes.
original owner cannot challenge after long lapse.
After long lapse, that is
waiver,
there. And if the original owner hasn't,
then you cannot.
Then subsequently you cannot.
Stepping into shoes and
stepping into shoes, etc. So this is the concept that is there in each of these judgments that I've given. I've given your lordship the paragraph numbers from Shiv Kumar onwards to Government of Delhi versus Sunil Jain. Each of them says the same thing. If your lordship wants, I can take your lordship into these, but I think that the compilation would work. But I'm placing reliance on each.
Yes.
Now, my lord. So this is, my lord, the first infirmity. So your writ petition goes. And need I, my lord, may I make this submission, my lord, with great respect to all concerned, that it is for this reason that the dates of the acquisition of title were kept, were not indicated, the conveyances not annexed, leave was craved to refer to them. The counter argument would be, why did the respondents not seek them? To that, the argument would be, it's not for the respondents to make out the case of the petitioner. These are not special within the special knowledge of the respondents. This is within your special knowledge. You are the title holder. Now, my lord, kindly sees, this is the first bar. The second bar is this. Therefore, you can't hit 17 today, my lord. You can't hit 17 today. Whatever was or was not the urgency of 17 is, going by the colloquial expression, not with none of your business. If that is not the case, then your entire case falls flat, because it's on the 17 hit that your 11A is triggered. You are well aware that without hitting 17, you can't succeed in 11A. And yet when the matter is moved before the learned single judge, two-page affidavits are shown in the form of reports. Let me show these reports.
Let us complete these judgments.
Also, these judgments? Okay, fair. The second is regarding, my lord, the
Para 8 is that if there is 17.4, then no 11A applicability.
Yes.
Oh, that all the judgments are on that.
Yes, Indore.
Indore, yes. Indore is cited for several reasons. So.
Yes, one of them is this. The other is, my lord, that
right.
section 23.
Yes, right.
15. These legal points, Lord, I'll have to elaborate in detail. It requires a bit of hearing. But then at first flush,
Elaboration.
the
You've
elaboration.
already elaborated sufficiently.
Yes, no, I mean, as far as the judgments are concerned, I may be required to place them, but I'm not doing that at this stage. If they distinguish it sufficiently, my lord, then I'd reply, kindly permit me to go through them once. I think that will be, for the time being, my lord,
These judgments, you have referred to so many judgments.
yes, on various,
All are not in the index.
yes, it's given, my lord, in the index.
Yes, we have missed a page, right? So 27 judgments in total.
I am sorry.
Why do you repeat judgments, Mr. Banerjee?
I mean,
One or
just
two
for the
suffice.
proposition, may I do this? I will not then formally cite all.
No,
I'll
yes,
scan a few and
yes. Tell us which ones to go through, and this compilation remains, but we'll just put a tick mark against
tick
those.
mark against that.
So, what are the propositions on which you have cited judgments? One is this.
Basically, two broad propositions. In fact, 5 broad propositions. Maybe other judgments, Lord, are not necessary. That one broad proposition is no locus standi.
Being the successors in interest of people who did not challenge.
There are 3 sublimes of that proposition. Number 1, non-disclosure of dates of acquisition, dates of conveyances in the writ petition, withdrawal of adverse inference. Number 2, 11A lapse not possible in case of a proceeding under where the notice
That's
is
a different, not a sub argument.
No, sub arguments are over there.
Yes.
3 is a sub argument of that. In 3 is you can't get out of the the subsequent purchaser taboo by saying that you came to learn of this in 2023 because of constructive notice.
We can find out 3. Apparently, at first blush, there are 3 strong main grounds. One is that post section 4.6 transfer, you cannot challenge a section 4.6 proceeding unless the predecessor challenged. So here there is nothing to indicate when the purchase event. Branch of that is non-disclosure of the dates. Even if they are the original purchasers, I mean at previous purchasers, even then there is nothing to show that they previously challenged.
Yes.
So even irrespective of that, the waiver
The second point is also
may apply.
Yes.
And constructive notice is also an adjunct to that. I mean, it's constructive notice, therefore you did not challenge, so waiver.
So waiver.
Section 17 is another ground. If there is section 17, no 11A.
No 11A. Fiction can't be extended
Fiction can't
beyond
be
the object.
And another ground which you actually argued, that no objection certificate, this was beyond the reliefs. And secondly, the no objection certificate requirement is independent of acquisition.
Yes.
These are the 2 limbs. So these are your
these are below the broad submissions on which, and there are other submissions, other points which I must take, that the writ petition should fail on the ground of suppression of material facts.
Like the non-disclosure of the purchase date.
The most material fact for everything. Non-disclosure of the purchase dates and the purchase deeds. The writ petition should also fail on the ground of a third case being argued. Horse, the case made out in the writ petition. The third case argued was, state has told me it has lapsed. See, there are 2 letters of the state. Therefore, it has lapsed. Therefore, that's an 11A lapse. The argument in the writ is 4 read with 17. 17 element is bad. Therefore, the 17 is a phantasma. There's no existence of 17. I'm so sorry. The 17 is a moonshine.
Mr. Bhattacharya.
There is
Phantasma for Mr. Bhattacharya and moonshine for Mr.
Moonshine for.
Please, only with leave of my learned senior, a new memorandum of appeal is being argued. It is not in the original memorandum of
This is Mr. Bhattacharya's standard rebuttal to everyone. This kind of puts everyone off and says, oh my God, 45 minutes wasted. This man can surely do it, so he's doing it. So this is trying to put in, Milord, personal experiences with pleadings. This is I congratulate him, Milord. I mean, the one sentence to really disarm everybody and say, oh, is it? So it's not there in the memo. Yes, I'll read it.
Yes.
I'll read the memo. So, Milord, insofar as this point is concerned, suppression.
So this is all what remains.
Suppression
You can show the reports if you want.
And I'll just show you, Lordship, the two reports on the basis of which the learned judge was not taken. Acha, 4, my lord, it's very important is they have abandoned 17, challenge to 17.
Have they abandoned?
Where is the challenge? I'm
It's-
asking
it's
myself.
not
Please have a
argued.
look.
That doesn't mean.
Abandoned. No cross appeal saying that I ought to have argued, left it free. Appeal is a continuation of the suit, but some issues cannot be kept in the pocket to be taken out at appeal. My next argument is, while arguing the matters in issues at the final hearing of arguments, plaintiff chose to abandon issues X to Y because they didn't argue on it.
All right.
Now in appeal, at the final hearing of my appeal, there is not even a cross objection saying that those points were argued or could be argued or are available for me to argue, etc. Look, these are more or less. May I just show the two reports and then you
Report,
have
yes,
control?
yes.
The two report দুটোকে আমাকে দেখান। Please see 219.
Mr. Cordy, you are leading Mr. Bhattacharya.
It's difficult
It's difficult to say whether it's more difficult to face Mr. Banerjee or to lead Mr. Bhattacharya.
I was thinking whether I should leave
Then
and
Milord, it is
leave
better,
them
Milord.
for a free
Free for all.
The SSC matter is going on, I am going.
You have to choose who is the devil and who is the deep sea.
Here the devil is as deep as the sea.
তুমি আর আমি একদিকে একটা মামলা দিয়ে আছি সেটা বলো।
Yes, Mr.
Yes. Just Lord,
Everything ultimately comes to the court, so we have to suffer everything.
just imagine well, what kind of a reputation will have some of us have earned.
Definitely,
No, it's in jest. It's always in jest.
just in jest.
আচ্ছা দেখি ইয়ে কর ওটা বল তুই ওখানে কি
219 of state petition, our report.
please have my lord page 219. This is my report.
State report আমাদের কাছে আলাদা আছে because we were not given a copy.
Yes.
Paragraph 2, page 220.
Hmm.
By an order dated 5th of July 2023, this Honorable Court was pleased to pass an order directing the respondents to submit reports in the form of affidavit in the instant writ petition. The instant affidavit is being filed pursuant to such direction. Now, my lord, 5. It is humbly submitted that the plots of land forming the subject matter of the writ petition situated in Chapna Mouja are required for the development of New Town project in Kolkata.
Whatever else
It's not there. It's not there.
8
It's not-
is important because you say falls
Plot
within
of
the
land
planning area,
forms within the plan, falls within planning area included in the LUDCP.
land use and development control plan.
Statements made.
Therefore, those have to be
That-
complied.
that's
your stand. What is the state stand?
State says it's lapsed.
What is that?
Kindly see. কত?
appeal আমাদের কাছে আলাদা copy.
It is not there in the appeal. There is a separate copy which was given before the first court. We were not favored with a.
It is in your lordship's records. Before the other file was handed over, subject to correction.
দেখুন তো এরকম রিপোর্ট আছে এতে দেখুন এইরকম রিপোর্ট ইন দ্য ফর্ম অফ অ্যাফিডেভিট স্টেটেড
Yes,
The
yes,
back
yes.
sheet of Mr.
It is
Dey.
there. It is there. Report in the form of affidavit. Sorry, report. Yes. Respondents 2 and 3.
Respondent numbers 2 and 3 in compliance with the honorable court's
Yes,
order.
yes.
Not in the back sheet of Mr. Dey.
এটা দুটো কপি আছে বোধহয় দুটো এখানে চলে এসছে yes
আমরা 2
what was the stand there let us see yes declarations they must be sticking to section 17 they don't
they are saying it's lapsed para 5
it's like
and that's precisely why the writ has been filed.
no but 6 and 7 how is it reconciled let us see 6 para 6 says back the not being visible
State is arguing against the own provisions of the statute.
opposition could not be
So where is the lapse under 11A?
acha Possession is an essential ingredient for 17 to come.
But here, unlike section 3 of the West Bengal Acts, where along with the notice, section 4, where along
That's
with the
different.
notice it is taken, here also possession follows the notice, is a state
Section-
subsequent.
Section 16 makes it clear that possession is the time when it vests in the state.
In
And-
in regular case.
So in all cases, section 16 is applicable. Section 16 says that when the collector has made an award under 11, he may take possession of the land.
11.
Right, you are right.
Can
But
you come-
even 17 itself says that in cases of urgency, though no award has been made, may on expiration take possession of any land. Such land shall thereupon vest absolutely.
the moment you take possession.
The moment you take possession.
So it doesn't await.
They say that possession has never been taken.
That's the state stand.
State
Result
stand.
is
If the
lapse
state
under
says that-
11A. I'm asking myself. Lapse under 11A. Please test this. These are fictions. There's no purposive reading of a fiction. Fiction.
No, not merely a fiction, it's a bar also to.
Yes, but it's a fictional bar. Something happened. Something is a bar is
Why do you
introduced.
say it's a fiction? It's
Bar
not
is
fiction.
introduced. No, it's a fiction. Please have a look at 11A.
It's
Just
a
once.
statutory bar.
Yes. Statutory bar is
Then-
the consequence.
Then Enter Limitation Act is a fiction.
In a way it is, because it makes something which is applicable today inapplicable tomorrow because of something that has happened.
Fictions are legal fictions like idol is a perpetual minor. This is a
That's one of it. So
legal fiction. It
Then-
is not a minor, it is not a human being. But you are personifying the idol and saying that it's
giving
a,
it certain rights. Like this, here is also a legal fiction. What is a legal fiction? Anything
this
which
is a
would,
statutory bar. You cannot do this after a time.
with great respect, bar is the consequence. A fiction may be
What is the fiction here?
a fiction. The fiction is, if these circumstances happen or do not happen, then with the coming of a given date, fictionally, that proceeding would be non-est. Lord, I'll cite Lord, judgments on fiction. Lord, they're there if necessary.
Thank you very much.
Necessary. They won't be necessary. It's
We'll do our homework on fiction other than legal matters.
fictionally. No, but then that is a
Let
fiction.
us come to section 9 once then.
Yes.
So that is the stand taken. That's a very crucial stand.
Hmm.
Which will be the first point Mr. Kaur will be arguing.
Yes.
The collector shall then cause public nuisance.
Please compare it with 17.
Yes, section 17(1) says that though no award has been made, may on expiration of 15 days from the publication of the notice mentioned in section 9. So here they say there was no section 9. Section 9 has not been completed. So 17(1) does not come in at all.
Effect
11A? Everything revised.
without challenge of 17. Lord, I'm asking myself.
17 does not come into play at all.
17 came in
Unless
the
there is a position taken under section 9.
I tell you,
9, 15 days notice, then position.
possession is the consequence. 17
Position
comes
is a precondition for section 17 to operate, Mr. Banerjee. Position is a precondition, not a consequence.
Please see
In
17.
cases of urgency, whenever the appropriate government so directs,
Yes.
the collector, though no such award has been made, may on expiration of 15 days from publication of section 9 notice, take possession of any land. Such land shall thereupon vest absolute in the government. This is a case where possession is the precondition, not a consequence of section 17. Section 17 will only be attracted if there is a possession under section 9. It's a precondition of section 17. 17 is a consequence. If possession is taken under section 9, which is the precondition, then the consequence is section 17 comes in.
Lord, could you Lordship look at it in another way? Lord, 4, 5A, 6, 7, 8, 9 is the regular table. If 17 has to come in, 17 has to rear its head at the 4th stage in order to bypass 5A, come to 9, and then come into 17.1. 17.1 is the vestitive effect. 17 is the entirety of the proceeding. Please pardon me, my lord, if I am why I am saying this is, unless you attach 17 to 4, you can't dispense with 5A. 5A is a very valuable right. If it is dispensed with, it can only be dispensed with if 17 is attached to 4. So the moment 17 is attached to 4,
So, if
yes,
section 4 notice does not culminate in possession being taken under 9, then the notice itself becomes bad. Because the section, if it's a section 4 notice declaring and coupled with a section 6, declaring that the vesting will be done under, acquisition will be done under section 17. And if no possession under section 9 is taken, then the section 4 and 6 becomes, is rendered infructuous.
but there are some judgments which say 4 and 6 survive. 4 and 6 survive. That is the purposive reading into these expropriatory statutes, my lord, is restricted to a certain extent. It's available in other statutes, in enabling statutes, in welfare legislation. But here, they are almost reading it like penal statutes, not giving any leeway for any
Section
interpretation.
11A then applies, because the language of section 11A is, if section 17 is complied, 17(1), by taking possession under section 9 after giving 15-day notice, then section 11A is rendered academic, not applicable. But section 11A is nonetheless applicable if section 17 is not resorted to, coupled with section 9. Not resort, because section 11A pertains to the notice under section 6 itself. So whether the section 6 notice mentions section 17 or usual course acquisition, either way, section 11A becomes applicable unless that possession is taken. If possession is taken, land vests. But 11A says the collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration. Whether the declaration cites section 17 or does not, immaterial. From declaration, if no award is made within that period, this is nullified by section 17, read with section 9. If possession is taken under section 9, then section 17, yes, that notice culminates.
But what
It reaches fruition.
Yes, but at that stage, when the 4 is issued, 4 with 17 is issued in
the valid notice.
In terms of an urgency perception and in terms of emergency powers. The ultimate fruit of that may not have come in the end. What I am asking myself is, does it stop becoming 17 at all? But in all senses, from the beginning, ab initio. That's
Section
the question I'm asking.
17 does not come into play at all.
17
No possession is taken.
May I show you, Lordship, the notice under section 4 just once, just in order to establish this fact that this is an entry-level condition.
147.
Please come to Lord page 147. It's an entry-level condition. I mean, writing or not writing this wouldn't have made any difference, but it does in this case because they're invoking emergency provisions. Please have a look, Lord, at page 146. 147 is the typed copy. (146), my lord, see. Entry level. Whereas it appears the governor land is likely to be taken by government for a public purpose. That's the usual section 4 in the Moja Chapna.
No, this is page 146.
146 P2. The 147 is the typed copy. I'm showing you, Lordship.
P2.
P2 to later.
P8.
P2
146 is P8.
There are two
Oh,
markings.
yes, these markings on top. These stencil ones. The
All right.
printed one.
Thank you.
146 P2.
Yes.
Please see Milord 4. Whereas it appears to the governor that land is likely to be needed to be taken by government at the public expense for a public purpose, that is for New Town project Rajarhat in the Moja Chapna jurisdiction list so and so, it is hereby notified that for the above purpose, a piece of land comprising revisional settlement plots as detailed below and measuring more or less 0.769 hectares, 1.9 acres, bounded as specified below, is likely to be needed within the aforesaid Moja Chapna. This notification is made under the provisions of section 4 of Act 1 of 1894 to all whom it may concern. A plan of the land may be inspected in the office of the LA Collector, North 20 Parganas, in exercise of the powers conferred by the aforesaid section, The governor is pleased to authorize the officers for the time being engaged in the undertaking with their servants and workmen to enter upon and survey the land and do all acts required or permitted by that section, that's section 4. In exercise of the powers conferred by subsection 4 of section 17 of the Land Acquisition Act 1894, the governor is pleased to direct that the provisions of section 5A shall not apply to the lands, please see not the type copy to the right, shall not apply to the lands described in the schedule below, to which, in the opinion of the governor, the provisions of section 17(1) of the said act are applicable. So, formation of opinion, unleashing of 17.
So what is the question of urgency then if it's not taken, person is not taken over so many years?
Who's asking? And when?
They are not challenging the section 4 or 6. They are saying that the section 4, 6 have become toothless because section 17 has not been resorted to.
No, they are saying that the invocation of 17 was unjustified. Please have a look. That's why I placed the writ. I ordinarily don't will not argue.
Invocation of section 17 was
unjustified.
Yes. That's the prayer.
That's the writ. That's why I showed you, Lordship. No, the entire pleadings. There are pleadings galore on this. The invocation of 17 is unjustified. That, according to me,
what
means,
according to you would be the interplay of section 11A and 17 if 17 is not invoked?
According to me, if there is no,
then
no
can you
17,
wait for infinity to take
lapse,
position?
Then lapse.
And will it lapse?
My lord?
If 11A is not applicable.
No, in a 17-like scenario, legal gray area. You can't borrow the fiction. Legal gray area.
But urgency has to be given a meaning.
I admit. No, urgency has to be given a meaning. The unleashing of that urgency is at the initial stage.
But by the very fact that no position has been taken,
so
the premise of the section 4 notice goes also. Because it's evident that there was no urgency.
Therefore, would your
that
lordship,
is their case also.
Therefore, your lordship,
there was no urgency.
No, my lord, that is their case that there's no urgency. But they say that the invocation of 17 itself was bad. They are challenging the entry level 17.
Invocation of section 17 in the section 4 notice and section 6 notice.
Section 4 read with section 17, dispensing with 5A.
Invocation was of section 17. 17 does not contemplate a notice. Invocation of section 17 was by virtue of that section 4 notice.
Yes.
In the section 4 notice, 17 was invoked.
17 was invoked, thereby dispensing with 5A.
That has been challenged by them. The premise of one of the premises of the challenge, Mr. Banerjee, is that there was no urgency. So they could not have invoked 17. Yes. That stand has been vindicated by the state not taking position till date.
But that has not been argued.
For decades.
My lords.
For decades, no position has been taken. It's very evident from the materials on record.
I am on 11A. 11A will not be stretched left or right. It's a gray area. I admit. It's a gray area. But how 11A? That's what I'm asking myself. I thought long and hard over it. That fiction can't be extended to give them benefit.
So even now, under section 17, that section 4 and 6 notices remain alive.
There are certain judgments where they say that even after lapse, 4 and 6 remains alive. I am confused.
No, that is 2013 interplay with 1894 Act, 2013 Act.
No,
those judgments.
That's the section 23 entry level judgments. That is Indore. I'm not on Indore. Prior to
Indore
and
also, other judgments.
Prior to Indore also, there are certain judgments which say that 4 and 6 remain alive even after there is a lapse. So 4 and 6 by themselves are statutory events which are happening. Lapse means discontinuance. Lapse is a discontinuance. Lapse, my lord, I was taking to be lapse in the sense of let us say striking down of a statutory provision by the Constitutional Court. Lapse is not like that.
So let us
it's not taken out of the statute book.
Understood. We'll hear Mr. Cord on that after you come back.
Yes, Lord, could you, Lordship, Lord, from 2 p.m. I'm having some difficulty.
No, we'll continue with the matter. Mr. Cord is there. He'll be arguing. Mr. Basu will be there.
Lord, then,
if your turn of reply comes, then we'll.
If the turn of reply comes,
yes.
then Lord, kindly hear me in reply, my Lord.
Some other day. So we'll continue with Mr. Cord.
Yes, we'll come back. ठीक है
Yes.
But, yeah,
Yes.
first, show your lordships what were the facts on which, Lord, we had come to court. Lord, under
Yes.
section 46 of the West Bengal Town and Country Planning Act,
Yes.
Lord, we have to apply to the planning authority for a no objection first. Because, Lord, if we have to develop our land, we need a permission and no objection with regard to the status of the land. This no objection is to be required first.
Yes.
Now, Lord,
That is also of 1948.
that is, Lord, 1979, West Bengal Town and Country.
Town and country.
Now, Lord, what we do, we apply for a no objection in respect of various plots of land which we own. Now, Lord, there is a rejection. Please come to page 150.
Rejection on the ground that it has.
On the ground, no, or not in respect of all the plots, but only in respect of 5 plots, which they say are subject matter of the land acquisition proceedings.
So the dispute is regarding those 5.
Those 5. Kindly, my lord, come to page 158.
Yes.
May I just kindly see the subject, your prayer for LUTCP clearance of your proposed residential project in RS Dag number.
Sorry, I again
Lord,
wrote the wrong.
kindly see the printed
Yes,
page.
yes, my mistake.
Kindly see the printed
158.
158.
Yes. Right.
Kindly see the subject. It says your prayer for LUTCP clearance of your proposed residential project in RS Dag numbers. Then, Lord, various Dag numbers are given. Within Moja Chhapna, jail number 35.
Yes.
Then it says your letter of 19th December. Please see the subject. It says, with reference to your letter mentioned above, I would like to inform you that on scrutiny of the land details of your proposed residential project in Moja Chhapna, it has been found that parts of RS Dag number, this 5, 37, 38, 39, 44 and 45, in the said Moja are included in the pending LA case number such and such of 2005-6 and fall within the project area of HIDCO. However, RS Dag numbers, then Lord, there are 9 Dag numbers which are also mine, which I applied, within the said Moja are not acquired and are within the planning area of HIDCO. One is Lord project area, the other is calling, they are calling planning area. The project area, because Lord, they feel that this is under land acquisition case. Then Lord, the next paragraph. Under the circumstances, HIDCO may issue LUDCP clearance of your said project as per LUDCP of the new town planning area only for the land plots which are not involved in the LA proposal of HIDCO and are located within the new town planning area. So, Lord, this is the reason why we come to court. That, Lord, these 5 plots, they are not willing to issue NOC. They are only willing to issue NOC in respect of these other 9 plots.
That's why you sought that declaration that has lapsed.
And declaration lapsed only in respect of those 5 plots. Lord, your lordships may kindly, Lord, see the map once, which is at page 195. It will give your lordships a bird's eye view of the location.
Yes.
Lord, your lordships may kindly come to page 195.
Yes.
My lord will see where towards the bottom, Lord, Dag numbers 38, 37, 45, 39 and 44. These are the 5 plots. The other plots are on the upper side.
Yes.
They are, Lord, there is no problem. Now, my lord, this is the controversy with which we come to court. Now, my lord, my learned friend has talked about that we are.
So you did not challenge any refusal. There was no refusal as such per se. It was only refused. It was said that because those are pending under the LA case, and if that LA case hindrance is removed, then obviously you have a right.
I came to court only to remove that hindrance. This is the reason, Lord, why I am in court. Now, Lord, kindly see, Lord, when I bought these lands, Lord, it's not that I bought it, Lord, with my eyes closed. Kindly, Lord, see, what just one or two documents. Lord, if your lordships, Lord, kindly see one document at page 179.
Yes.
Lord, kindly see, this is, Lord, kindly see the subject, information in respect of application of HON'BLE Dash, one of the persons, Lord, who applied. With reference to the above, this is to inform that after verification of all available relevant files, it appears that RS plot number such and such, PS such and part of such and such, respectively in LA case number such and such for the new township Rajarhat. But after publication of declaration under 6 in the Calcutta Gazette, such and such, the proceedings has been lapsed under the provisions as envisaged in LA Act 1894. This office did not receive any drop proposal from the requiring body till date. This is the situation. So government, Lord, said in no unequivocal terms that, Lord, proceedings has dropped. Lord, as your lordships knows, Lord, right to property is, Lord, a lower constitutional right. Article 300 capital A is there. Now, Lord, this can be, Lord, interfered with,
Curtailed, yes.
curtailed, subject to, Lord, compliance with the statutory provision.
Yes.
So, Lord, if there is no vesting of the land through the land acquisition proceedings, Lord, the right remains intact of the owner to transfer the property. So, Lord, apart from that, we had made, Lord, also, Lord, other queries. If your lordships kindly take, Lord, one other page, please come to page 174. This is in 2011.
Yes.
This is also, Lord, lordship will find that HON'BLE Dash says this is to inform you that acquisition status of different plots of Mauja, Rajarhat as sought for are as follows as per available records. Kindly see these 5 plots, they say partly under acquisition proposal for the purpose of NTP Rajarhat project. Has your lordship found that?
Yes, yes.
And the others, Lord, for example, the other plots on which the inquiry was, they are all, Lord, 25, 26, 27, they are, Lord, at the bottom. Your lordships will find it
Not under any
acquisition. So, Lord, in so far as my title is concerned, when rejection is made, there is no issue raised that you are not owner, how are you asking for no objection, etc. The principal objection was that in respect of these 5 plots, there are LA cases pending. Now, Lord, when we came to the reed court, the learned judge, Lord, first asked for a report in the form of an affidavit. Lord, let me first show the report, Lord, that the appellant had filed. This is at page 219, its second volume in your lordship's brief. Arekta volume name? Page 219. একটা ভলিউমেই আছে আচ্ছা না
only one volume.
219. Oh, page 219, Lord.
219, yes.
The lordships will find a report in the form of affidavit filed by the respondent number 6. Has your lordship got that?
Yes.
Lord, please come to paragraph 2, where they say that they are filing the report pursuant to an order passed by the court. Then, Lord, please come to paragraph 5. Yes. It is humbly submitted that the plots of land forming the subject matter of the writ petition situated at Chapna Moja required for development of new town project in Kolkata. Then, accordingly, the land acquisition collector North 24 Parganas was requested to take necessary action for acquisition of plots of land. The land acquisition collector had accordingly taken immediate necessary steps for acquiring the plot of land. The answering respondent is not fully aware to the exact steps which have been taken by the said authority with regard to acquisition of plot of land, and as such it is humbly stated that the land acquisition collector North 24 Parganas is the competent authority to indicate to this honorable court the steps taken by it with regard to the acquisition of the plots of land forming subject matter of the instant writ petition. It is, however, stated that the plots of land forming subject matter of the instant writ petition fall within the planning area of HIDCO and is also included within the land use development control plan and also falls within the relevant land use development control plan. So they are the Lord planning authority. This is what they say. This is what the report is. And they say we can't say it is the land acquisition collector who will be in a best position to say. And the land acquisition collector's report, the state's report, your lordship has already seen, where the state says that we have not taken possession, it has not vested. In fact, Lord, page 145, if your lordships, what? 178, sorry. If your lordships kindly have a look at page 178. Lord, this is dated 2011. Kindly see, Lord, the last 4 lines. The sentence starting with the word possession of the said RS Dag number. Yes. Along with some other RS Dag number involved in case number such and such is not handed over yet to the requiring body of housing department. So, I mean, it says that possession has not been handed over. State in its report says state itself has not taken possession. How could it hand over? Now, Lord, faced with this situation, Lord, your lordships may kindly see your lordship has seen the judgment, Lord, the London. Yes. It's fairly simple, Lord. It really says that if you have not acquired, just give no objection in respect of the other plots also, because there is principally no dispute with regard to the certain plots, 9 plots. Right. The 5 plots, she says that your lordships will find that she has indicated. Now, Lord, on the point that my learned friend has raised, yes, I just want to take 5 minutes, Lord, on the interpretation of the Act. Lord, if your lordships kindly first take section 17. Yes. The 17, Lord, has a scheme of its own. Now, your lordships will kindly see 17.1 talks about the urgency and the direction of the government to the collector that they can take possession of any land needed for a public purpose. 17.1. Has your lordship found that? Yes. Now, 17.3a was inserted with the amendment of 1984. If your lordships kindly take note of 3a, it says before taking possession of any land under subsection 1 or subsection 2, the collector shall, without prejudice to the provisions of subsection 3, tender payment of 80% of the compensation for such land as estimated by him to the persons interested entitled thereto, and pay it to them unless prevented by some one or more of the contingencies mentioned in section 31 subsection 2. And where the collector is so prevented, then 31 subsection 2 shall apply as they apply to the payment of compensation under that section. Then Lord 4. Here, Lord, 3a 17.1 has not been invoked. What is invoked is 17.4 along with the notice under section 4. Now, Lord, what is the effect of 4? It dispenses with 5a. And that is the only thing which is dispensed with. So, my lord, section 6 remains, section 7, 9, 11, every other provision remains. Now, my lord, if 11 remains, Lord, 11A also remains. Now, Lord, kindly let us test it. Lord, 17.4 says 5A is dispensed with. It says the may direct that the provisions of section 5A shall not apply, and if it does so direct, a declaration may be made under section 6 in respect of the land. So 5A is a right of objection, which is dispensed with at the initial stage. And section 6 can straightaway come in after 4. But after that, Lord, one has to follow the scheme, the original scheme.
Everything follows.
Everything.
6 onwards.
6 onwards, everything follows.
And possession can be taken after that up to section 9. After section 9.
After section 9, unless the state has taken possession in terms of 17.1 by putting in the 80% of the compensation, which is not the case here.
No, 80% compensation, even then,
The award has to be made. Ultimate award,
ultimately it will be made.
Wait.
Award is postponed in case of 17.
Huh.
But before taking, 3A says, before taking possession of any land under subsection 1 or 2, collector shall without prejudice such and such. So the possession is taken under 1 or 2. 1 and 2.
1 or 2,
1 or 2.
subject to payment of the compensation.
But one presupposes that in cases of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, that means before 11th stage, may on the expiration of 15 days from the publication of the notice mentioned in section 9 take possession.
Yes.
So section 9, that formality has to be complied with even in case of 3.
Even in case of 3.
Yes.
But only the possession can be taken over subject to payment of 80%.
Yes, that payment has to be made.
These are the preconditions of taking possession under 17.1. But we are not facing a situation of 17.1. So I need not, Lord, bother your lordships on this. We are only concerned with 17.4. And 17.4 merely, Lord, dispenses with the provisions of section 5A. So 5A is just the initial objection. That's taken off. But Lord, then after 6, the objection at the stage of 9 remains.
In fact, yes, 9 starts with 9 is connected with the previous sections.
Yes.
Because 9 says the collector shall then cause public notice.
7, 8 after.
So therefore, in a 17.4 scenario, what happens is section 4 has to be there first.
Yes.
Then section 17.4, in the section 4 it's indicated it will be a section 17.4 situation. So therefore what happens, 5A is given a go by.
Correct.
Then 6, we jump to 6. 6 declaration is made, which is also evident from the scheme of this section 17 itself. Section 6, 17.
Yes.
So then section 6 notice is published.
Yes.
After that, 7 also must come in then.
Yes.
Whatever follows will come in.
And measuring of land.
Measuring of land, yes.
That
7.
also comes. And then 9. 9 is the hearing of objection.
Yes.
So
Everything else remains.
Absolutely, Lord. Under the scheme of act, scheme of this act, 2 stages objections are there. One at 5A,
5A and
then 9.
9.
So, Lord, 5A is dispensed with. 9 remains.
9 remains.
And Lord, all the subsequent steps which is required post 9, one has to go to Lord 10, then 11.
Yes.
And their time schedule, which is contained in 11A, obviously, Lord, applies. And until the possession is taken, as your lordships rightly pointed out, there is no question of vesting. And unless the pay, there is no question of possession.
Section 16 has an overriding effect regarding vesting, when vesting occurs.
Absolutely.
And 9 is in consonance with that, because possession is the thing. Possession is the...
Absolutely. So, Lord, at the stage of NOC, Lord, is the appellant required to go into this aspect? Either it is acquired, for which the land will be recorded in the name of the government. If it is not recorded in the name of the government, they are hardly bothered. And Lord, the appeal and all these points that the appellant has taken, contrary to the acquisition proceedings, it has lapsed. The government says it has lapsed. This is, Lord, a clear case of, Lord, a complete harassment, Lord, at the hands of the authority.
So therefore, there are two effects of 17(4). One is section 5A is dispensed with.
Yes.
Secondly, section 10 and 11 are postponed till after the possession. These are the only two effects we can think of.
Absolutely.
Because otherwise, if there was no 17(4), then 5A had to be resorted to, and even after 9, this 10, 11, this award has to be passed, and then the possession is taken under section 16 indicates that then it will be.
The only thing is dispensed with under 17(4 is
5A is dispensed with, and 10 and 11 are postponed.
10 and 11, Lord, postponed in the sense that that process has to be
postponed till after the possession.
Till after the possession. No, only 11, Lord, they can be simultaneous. They can, Lord, award, payment and possession that can come, Lord.
So that payment is under 17, 3A.
No, 3A is under
17(1).
17(1).
Yes.
That is different.
Different, yes.
This is 17(1) was never invoked. This is not the case. Only 17(4) was invoked.
Right.
So 17(4) does not, Lord, anyway affect either 9, 10 or 11. 17(4) only dispenses with 5A. One stage of objection.
No, but in a normal situation, if there is no 17, when can the possession be taken?
Possession taken, Lord, after the award. If your lordships, Lord, kindly come to section 11.
That is what we are, yes. That is what we are saying that, yes, 10. 11 inquire, the collector shall proceed to inquire, and then
Lord, kindly take section 16. I'm sorry,
16,
your lordship was right. Section 16. When the collector has made an award,
only when an award is made, then possession can be taken. So therefore, that means after 11, possession can be taken under normal circumstances.
Yes.
But in a 17(4) scenario, after 9, it can be taken.
Possession can't be taken under 17(4). Then one has to exercise power under 17(1). Your lordship.
Oh, yes.
Kindly come to 17(1).
Yes.
This is what it says. In cases of urgency, whenever the appropriate government so directs, collector through no such award has been made, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in section 9, subsection 1, take possession of any land needed for a public purpose. So this is also, Lord, power can be exercised after section 9. That's why I said that 17(1) situation never arose here.
17(1) and 17(4) are different.
It's completely different. Completely.
Two ecosystems.
Absolutely. And Lord, 17(4) comes at section 4 stage. It can come only at section 4 stage because 5A is being dispensed with. That's the only purpose why, Lord, 17(4) is invoked. Otherwise, Lord, 17(1), 17(2), these are, Lord, independent provisions.
And in this particular notice, 17(4) has been invoked.
17(4) only. Because your lordships may kindly have a look at that notification once. Section 4 and notification.
Yes. That notice is was placed.
Absolutely, Lord. 147 is the notification. Lordships can be.
Yes.
146, I'm sorry. He placed 146.
But if it's a 17(4) scenario, then everything has to be done.
Absolutely.
Then also possession has to be taken
post-award.
Post-award, yes.
Post-award. There is no, Lord, shortcut.
All remain. Everything remains excepting 5A.
Excepting 5.
Because in any event, there would be a dichotomy then. Otherwise, 17(1) contempt can set in only at the after a 4-6 scenario.
9. Even 9 scenario.
Yeah, 9.
Yes.
Because in this particular case, section 17 was mentioned in the section 4 notice. Mr. Banerjee is trying to connect section 4, taking back the effect of section 17 to section 4. But that is not possible in any event because section 17, only if it's 17(4), it has to be indicated because the very next step is 5A.
Correct.
5A to jump 5A, it has to be indicated in the
None
notice.
of the other provisions of section 17
Can come
come
at the section 4 stage.
at the fourth stage. It can only come in after
9.
stage.
9.
So all other provisions,
So-
17.1, 17.2,
If there is 17.4, what happens is 4 notice, 5 is skipped, 6, and everything else has to follow after award position is taken.
absolutely.
And if section 17.1 is invoked, then section 4, 6, everything happens.
Absolutely.
Everything happens.
Absolutely.
Only at the 9th stage, before waiting for the award of 11, under 11, after 9 you can take possession.
Possession under 17.1
Uh-huh.
by depositing 80% of the
80%. There too a protection has been given 80%, and probably the rest of the amount will be adjusted
in the
after
award.
section 11.
After section 11. Your lordship is absolutely right.
Very well. Actually, you are absolutely right. I just explained what you say.
No, Lord,
So
that's my reading of the statute.
Yes,
because,
yes.
Lord,
appears to be-
these are, Lord, sections which we keep reading, and every day we find something new. But this
Yes.
is my reading of the statute. I personally felt that no right of a owner is infringed unless one crosses the section 9 stage. Only dispensation that comes is 5A. But that is not affecting the right of the owner, because his objection remains at the 9th stage. So right of objection is
Still there.
still there.
No, but 17.1, if it's urgency, then irrespective of the objection, notice after 15 days possession can be taken.
Taken, but deposit of that,
Deposit has to be there, and ultimately award will be there.
and one has to cross the 9th stage.
Yes,
Here, my lord, we have not reached the 9th stage. The lordships may kindly take section
Nothing has been reached. Only section 4
and 6.
and 6.
6. So,
15 days, 15 years.
এটা দেখেছেন, এটা দেখেছেন. Yes, looked into
You have
that.
distributed one section among yourselves, each one of
No, my lord, my
this section has been missed out on the other.
friend was trying to point out the report that the state has filed. I said that your lordship has already looked into that.
State report. Yes,
of
yes.
the state. That your lordship has already
Yes.
looked into, where report says that compliance of section 9 has not been done.
Not been done.
And
No possession has been taken.
could not be
Yes,
taken. This sentence is, but in the incident case, because of urgency, compliance of section 4 and 6 has been done, but compliance of section 9 has not been done, and possession could not be taken. So correct stand. Unless they complete 9, they could not take possession.
No.
So, my lord, it has died its natural death,
Yes.
so to say. Lord, I didn't have to ask for that declaration. It
Yes,
has
if it's a section 17.4 scenario, then 11A applies, 11 applies, 11A applies, everything applies.
Lord, if it is 17.4 scenario, your lordship is right, everything applies,
Everything applies.
except for 5A.
Except for 5.
We don't need to read 5A in case of 17
Here actually 5A was given a go by and section 6 was issued. After that everything has to be followed,
After
including
that,
11.
nothing has happened.
So
And
therefore
that is-
11 applies. If 11 applies, then 11A applies.
11 applies, 11A applies.
Only in a section 17.1 situation, since possession with possession vesting happens, 11A may not apply.
May not apply, but where not this 80% has been paid.
But award has to be given.
Award-
11 comes in.
11,
But the proceeding does not lapse
correct, because
because it has already vested.
80% is paid and vested.
Right, right.
This both.
Yes.
And that
80% plus, absolutely, plus rest.
Therefore, Lord, this payment is a precondition.
Yes.
Your lordships will find 3A makes the
Yes,
payment
precondition.
precondition.
Right, right.
So therefore, there is no question of, Lord, reading, Lord, section 17, barring 17.
That was the question we asked Mr. Banerjee, that then in every case section 17 would be resorted to and possession would be taken. Why should the state take the trouble of going through the entire process?
So that is, Lord, the
There
crux
has to
of
be
the-
something to prevent.
Absolute.
Right, your reading appears to be correct subject to.
So, Lord, this is, Lord, the crux of the matter. My relief that I have claimed is only, Lord, relating to this NOC. I had applied and they are not giving in respect of these 5 plots. So, Lord, the court said that give NOC. There appears to be no
Yes.
impediment in issuing the NOC. Lord, my ownership has not been challenged. Even while rejecting my prayer for NOC, your lordships will not find that any question was raised with regard to the NOC. And it is immaterial, Lord, in my humble submissions, when I have acquired the property. Because if the property have not been vested, there is no question of there being any fetter on the owners, the erstwhile owners, to transfer the property.
Right.
It's absolutely immaterial in my humble submissions. Now, Lord, just one judgment on this confusion of 17.4, 17.1, though there is no confusion, but I thought, Lord,
Sometimes judgments create more confusion.
Lord, I think it is in the compilation. If your lordship,
Their compilation?
yes,
Good.
kindly, Lord, come to page 383. It is 2022 SCC online, SC 1408. Lord, I can give a copy, Lord, if your lordship.
No, don't. 2022 SCC online 1408.
1408.
Yes.
Lord,
So you are relying on this.
yes, Lord. Kindly, Lord, see the first paragraph. Your lordships will understand. This appeal has a checkered history. The appeal was heard by a bench consisting of 2 honorable judges, etc., and was decided with divergent opinion. In the process, after consideration, Honorable Justice so-and-so arrived at the conclusion that taking over possession of the land without complying the requirements under section 17(3)(a) of the Land Acquisition Act so-and-so is clearly illegal and in violation of the statutory provisions, which automatically violates the constitutional guarantee under 300 capital A. Lord, I need not trouble your lordship. Kindly, Lord, come to paragraph. The issues are not framed in para 8. These are the issues. Lord, kindly see B or A and B. Is the requirement of tendering payment of 80% of the estimated compensation as contemplated under section 3A, section 17 mandatory to ensure absolute vesting of the notified land? Whether the requirement to pass the award within the time frame contemplated under 11A applicable to the acquisition notified under section 17 of 1894 Act. Lord, there are discussions between para 12 to 16, which your lordships will find. Lord, these are the discussions that we also discussed just now.
Yes.
Paragraph 12 to 16. I'm not reading out to your lordship.
No need.
Kindly come to paragraph 13.
13.
1-3.
Yes.
That, I'm sorry, your lordship was reading paragraph 12.
No.
I thought 13.
We were reading 17. So
I'm so sorry. I'm so sorry.
No, 13.
Actually, Lord, 19 and 27 will give your lordships the conclusion. 13, Lord, it
No,
says,
13 he displays. No difficulty. If you want.
that apart, subsection 4 of 17 provides the discretion to the appropriate government to waive the application of the provisions of section 5A and make the declaration under section 6 in respect of the land at any time after the initial publication of the notification under section 4 of 1980-1994 Act. This makes it clear that even in a case where the appropriate government exercises its power to invoke the special power in case of urgency, all other procedure contemplated under the Act except the requirement under section 5A of the Act of 1994 is to be complied. Therefore, after issue of the initial notification under section 4 read with section 17(1) and on taking possession after issue of notice under section 9, the declaration under section 6 of the Act is to be made so as to complete the process of acquisition, which indicates that the objection to acquisition of the land shall alone stand muted and not the right of compensation which is to be paid in strict compliance with the requirement of that regard. This is the distinction the judgment says. 17(1) invoked, your right to compensation remains. But right to reclaim the land goes. If it is 17(1) coupled with 3A. Then, Lord, 17 is the paragraph your lordship was reading that really says that is mandatory. That
the development has also been considered here. Yes.
Kindly see 17 last 4 lines. It says the benefit of the said provision is available only to be invoked by the land losers and cannot be invoked by the acquiring authority to claim lapse by pointing to non-compliance, since vice of non-compliance cannot be permitted to be converted into virtue. I think this matches Mr. Banerjee's standard.
No, but the vocabulary is not up to the mark. Yes, the construction, sentence construction may be at best.
Blood
An unsuccessful effort at matching Mr. Banerjee.
So, Lord, these are my humble submissions. I don't want to take.
No, you said which paragraph? sir?
paragraph 27,
27. Acha,
that is the concluding
the-
paragraph. In the result, we pass the following order. 1. The provision contained in section 11A of 1894 Act shall be applicable to cases in which the acquiring authority has not complied with the requirement of subsection 3A of section 17 of the 1994 Act by tendering and paying 80% return of the estimated compensation, percentum of the compensation before taking possession, since possession in such cases cannot be considered to be taken in accordance with law and the vesting is not absolute. If the requirement is complied and the possession is taken after tendering and paying 80% term, though there is need to pass an award and pay
Yes.
balance.
Section 17(1) is not required to be considered at all
At
here
all.
because it was not quoted even in the section 4.
Number 1 and number 2, Lord, 9 stage had not come. That's the state
No.
government's report. The 9 has not
So
come.
if 17(4) is invoked, 5A goes, rest remains, award has to precede possession.
Absolutely.
But if 17(1) is invoked, then 5A remains. 5A is not taken away.
No.
Everything happens
But
at the
possession.
9th stage, you can take possession
Correct.
before the award.
Absolutely. Absolutely. This is the distinction. And Lord, we had come for a very, very short relief. We had come here saying that your
There was an apparent discrepancy because your relief says regarding land acquisition, and suddenly it is discussed and argued that regarding this urban. But the picture has been made clear by you because the cause of action may not always directly relate to the relief. Cause of action is the facts leading to the relief.
Absolutely. And Lord, it was essential for me to lay down these facts. Otherwise, Lord, suppression could have been alleged.
Right.
So, what in the process of laying down the facts,
Yeah.
it may be, Lord, out of over enthusiasm, it has been said that 17 was wrongly invoked and all that.
Yes.
But we were not under 17(4) or anything. We were only interested to get those objections in respect of those 5 plots overruled, saying
if an X refusal is based only on Y, then you may very well challenge the relief may be Y.
yes,
If you remove Y, then X goes automatically.
Absolutely.
X rejection goes. So
absolutely.
therefore, you need not seek for a relief regarding X
Correct.
because the refusal was only on the ground that it has been acquisition proceeding.
I had mentioned why in detail, and I had also mentioned that has lapsed.
Right.
So without
In
affecting,
the pleadings, you have stated all these things. Must have stated
I have. In fact, in the pleadings, everything is stated, and I have.
those are the annexes to the
Also
writ
in
petition
writ
also.
petition.
Yes.
Those are annexes to the writ
You
petition.
only placed those from the annexes to the writ
Annexes
petition.
to the writ petition. Acha, ठीक है.
Mr. Banerjee's section.
No, yes,
Which section is he?
he insists that
He's
your
in
lordship
charge of which section?
should look into this West Bengal Town and Country Planning Act once.
No, he's right.
Section
Actually, we should have looked into that.
Section 46, my lords may kindly yes, have a look at.
এটা আনিয়ে নিতে হবে এটা আমাদের prompt হয়ে যাচ্ছে good
Says any person
yes
or body excluding the Department of Central State Government, local authority, intending to carry out any development on any land shall make an application in writing to the planning authority or development authority for permission in such form and containing such particulars accompanied by documents and plans as may be prescribed. On such application having been duly made, then Lord
yes
may pass an order. The planning authority may pass an order 2A.
right
And this is where we are. The planning authority has passed an order rejecting those flood NOC in respect of those 5 plots. This is citing acquisition. Yes. হয়ে গেছে একটু বাদে একটু argument হয়ে গেছে
Yes, so when should you keep it?
So, my lord, these are my humble submissions.
Can it be on Tuesday?
Whichever date suits Mr. Banerjee, because he is to answer now.
Yes.
So we'll keep it on Tuesday. You have anything to add? Your stand is that the position was not taken.
No.
You did not take position, that's why. Well,
They did not reach up to 9, section 9. Section
fair enough, fair enough. Hard in part, the matter shall be listed for further hearing on September 9, 2025. 9th September, Tuesday.
May it retain its position, Lord.
Part heard matters are taken up above the other matters. Part heard, এটা থাকবে। Above the other hearings.
Much. Much.
Town and thank you. হ্যাঁ এই দুটো ঢুকবে এই কম্পাইলেশন অফ জাজমেন্টের সঙ্গে থাকবে হ্যাঁ
বুঝে যাবে
এগুলো দিনের দিন জাজমেন্ট হয়ে যাবে ও যদি আজকে না পোস্টপোন করতো আজকে জাজমেন্ট হবে ফাইলটা দাও আসবে
My lord, before my learned friend starts, my lord,
Yes.
I have a preliminary point of maintainability of the appeal of my lord. My lord.
This is item 6.
6, my lord.
Why not maintainable according to you?
My lord, the latest judgment of the Supreme Court says, my lord, all the relevant documents are required to be annexed with the stay application. They have skipped over the documents which, contrary to their submission, yesterday the submission was made before Lordship with regard to a single plot. But in the prayer of the writ petition, they prayed for allotment in respect of 2 plots.
Cite that judgment.
My lord, I have that.
Give the citation for your learned friends. So
Well,
that second, the reference should be given.
My lord, paragraph 32 of the judgment, my lord. 33, my lord, sorry, my lord.
30?
33, my lord. 2023 16 SCC 183. 23 16 SCC 183.
Page. 283.
33. Para 33.
Page 283.
16 183.
18.
183.
1618.
This is not an absolute proposition. And we don't know the rules of the Supreme Court. Those may require disclosure of all the documents.
But thing is this, yesterday when the matter was argued by the senior advocate, my lord, he vehemently argued that he prayed for allotment with regard to the single plot of land. But the prayer of the writ petition says, my lord, they prayed for allotment in respect of 2 plots of land.
Maybe. So why should the writ petition be disposed without hearing?
No, not, it has been hard. Writ petition was hard.
When the matter is called on for hearing, preliminary objection is taken by learned counsel for respondent number?
State, my lord.
For the state respondent.
Well.
On the ground that while the learned senior advocate appearing for the petitioner, appearing for the appellant, had argued on the previous occasion that the grievance of the appellant was in respect of 1 plot, the prayers in the writ petition pertained to 2 plots. Push up next parallel, learned counsel cites such and such reported at 2023 16 SCC 183, where it was held by the Honorable Supreme Court that the SLPs before the Supreme Court in that case appeared to have been filed declaring that all defects have been cured, and thereafter by way of an application seeking permission to file additional documents, comma, the petitioners had produced certain other documents. Full stop. The Honorable Supreme Court observed that apart from the fact that after filing of SLPs, no documents could have been filed without the permission of the court, comma, which in the said case did not appear to have been sought for by the petitioners, nor granted by the court, comma, the very practice of not filing essential and relevant documents, comma, more particularly the documents in respect of which a relief is sought in the SLPs, comma, was strongly deprecated. Full stop. It was noted that non-production of relevant documents, especially the documents in respect of which relief is sought, along with the SLPs, could be the sole ground for rejection of the SLPs at the outset. Full stop. Next para, however, comma, the said judgment does not lay down an absolute proposition of law governing writ petitions filed before high courts, comma, to the effect that unless all documents on the basis of which relief is sought are annexed to the writ petition itself, comma, the writ petition should be dismissed. Full stop. The judgment of the Honorable Apex Court was rendered in the context of the rules governing procedure in the Supreme Court and might not be directly germane for the purpose of considering a writ petition, the maintainability of a writ petition under the governing rules of this court. Full stop. Next para, that apart, comma, in the cited judgment itself, comma, the Supreme Court left a window of opportunity to the petitioner by observing that after filing of SLPs, no documents could have been filed without the permission of the court, comma, meaning thereby, comma, by necessary implication, comma, that documents may be brought on record with the permission of court even after filing of SLPs. Full stop. Hence, comma, this court is of the opinion that the writ petition cannot be rejected on the ground as raised by the state respondent at this stage, comma, since it would be premature to do so. Full stop. Accordingly, the objection as to maintainability of the writ petition is turned down and the writ petition is taken up for hearing. Yes. What was your argument? Remind us.
I am led by Mr. Satyam Subhash Lordship on basis of the settlement of the land Lordship, according to the government order Lordship, the plot of land settled in favor of the petitioners, appellant Lordship. They are residing there for long time Lordship. Their voter card.
Refugee rehabilitation, that scheme, that matter.
Yes, Lordship.
Yes.
Yes, Lordship. They have residing there for long time Lordship. The settlement was done.
They barely started, Mr. Basu, barely started.
Yes, Lordship. Subsequently, that was allotted in favor of the private respondent by way of.
Come then.
Yes, Lord.
What is the use of? At this juncture, comma,
Pass over, Lordship.
an adjournment is sought on the ground of
only pass over.
learned senior counsel appearing for the petitioner. Full stop. Let the matter stand adjourned for the day. We have a 3:30. No question of passover now.
I'm playing 2 days since Mr. Chaudhary has
What?
come. Since Mr. Dinabandhu Chaudhary.
On the you are for the petitioner.
Yes.
Appellant.
Appellant.
On the prayer of the appellant, the matter is adjourned for the day.
My.
I beg to appear for the petitioner. Yes. My lord, the affidavit of service confirms service upon all the respondent. The private respondent, my lord, will find at page 13 of the affidavit of service.
Private respondent is there. Your affidavit of service is there on the right side. Yes, Mr. Banerjee, what is that?
My contiguous plot holder was without any permission under the Land Reforms Act was illegally filling up the water body. My contiguous plot holder. Now, I complained before the land revenue authorities. They do not take any action. My lord, I prefer a writ petition before this honorable court. Preliminary on the ground of maintainability, my writ petition has been dismissed, saying that I have no locus. Your Lordship, may I bring your Lordship's attention to paragraph 3, that is at page 17 of my CAN application. This was the writ petition. Paragraph 3, page 17. My Lord has found?
Yes.
The said petitioner states that, my Lord has found, that Taposh Base, the private respondent herein, is the petitioner's neighbor and owner of water body situated at LR plot number such and such. The said water body is an integral part of the local ecosystem as various fish and water species grow therein. Thereafter, my Lord, the petitioner as well as the other adjacent plot holders are using the said water body and has become an integral part of his life. Therefore, my Lord, I demonstrate before the Honorable Single Judge that I have a right of user and my right of user is being infringed. Hence, I become a person aggrieved. My Lord, therefore, I prefer an application under Article 226 of the Constitution of India. Now, how the Honorable Court deals with it kindly takes the memorandum of appeal at paragraph 9. The Honorable Court holds,
Unless you plead an easement-ary right before a civil court, where is your locus standi to file a?
Yes, my Lord. My
As a
Lord,
complainant, you can at best lodge a complaint.
yes.
Right. Up to that, it's all right. Your duty ends there.
No, my locus, my Lord, I have two counts on which I have locus. First, my Lord, as an adjacent plot holder, my Lord, I take out a complaint. They remain mute spectator, my Lord, and I have a right of use, my Lord. Then I ask this question to myself. Admittedly, the pond is owned by the private respondent. Then I have to go to the civil court. The civil court will declare that I have an easementary right. Thereafter, I will come up to this Honorable Court. This is the first link. And alternatively, what has fallen from your Lordship, my Lord, even if a resident complains of statutory,
You can definitely.
no, under such circumstances, our courts have held, our division bench of our court has held that a resident complaining inaction can come under Article 226 of Constitution.
In any case, in every other case, we are directing authorities to take steps under Section 10 of the Highways Act.
Yes.
Encroachment.
Encroachment.
It's strictly speaking, there also they don't have locus standi.
Listen.
Because
My Lord, this has been held, my Lord. I have relied on that judgment before the Honorable Single Bench.
should be. Cite that judgment for us.
Judgment of the impugned order, or?
No, the judgment which you cited
Yes.
first, then.
Your Lordship, I tried my level best to get it from the SCC online, but I could not get. My Lord, this is the judgment.
Do you have the citation reference of the SCC online?
No. It is not
Oh, it is
available
not
in
there.
SCC online, my Lord. I have downloaded from the official website, High Court, Calcutta.
Right. But you give a copy to them then.
My Lord,
Unreported judgments, you have to give copies.
আপনারটা নিয়ে নেবেন একটু?
আগে করো তারপর দাও আমার আগে কোনার করবে কি করে
Your Lordship would kindly take paragraph 51.
Yes, we are in fact there.
Yes. In this manner, please. In this context of a writ petition alleging construction in violation of the building rules and the municipality not taking any action of the complaints regarding such violations, a resident of such municipality has locus to file maintain a writ petition. C. K. Ramdas Shenoy Supra for such proposition. Even a concerned citizen can maintain such a writ petition. C. Deepak Mukherjee Supra for the same. Thereafter, my Lord, kindly takes '48. I should have placed paragraph 48 first, my Lord. It's my fault, my Lord. Kindly takes paragraph 48 once.
Yes.
Lord, all the precedents have been relied upon. K. Ramdas Shenoy has held that an illegal construction materially affects the rights of all the enjoyment of a property by persons residing in a residential area. Learned single judge, while dealing with the issue of locus of the writ petitioner, has referred to various authorities of the Honorable Supreme Court. Thereafter, my lord, these judgments were all relied upon. My lord, the concept of locus standi has gone a sea change. And particularly, my lord, where construction is it's a grave allegation that he's filling up of a water body. And my first limb of my submission was that, my lord, I am directly being prejudiced, because otherwise then I have to, if I have to accept the analogy of the Honorable Court, my lord, of the Honorable Single Judge, then first I have to go before the.
Let us see the impugned order now.
Yes. Kindly takes paragraph 9.
Yes.
My lord,
9.
Shop Yes. My lord, I'm sorry, my lord. Before that, my lord, I placed paragraph 3. Paragraph 3. Mr. Banerjee, in course of his argument at the very outset, draws attention to this court to para 3 and 4, which I read over before, Lordship.
Yes.
It is submitted by Mr. Banerjee that it is the specific case of the writ petitioner is the contiguous owner of the land and the said water body, and the writ petitioner and his co-villagers are using the said water body for a considerable length of time. Thereafter, I place this division bench judgment, and paragraph 9, my lord will find, on careful consideration of the entire materials as placed before this court after hearing the learned advocates for the contending parties, this court finds sufficient justification in the submission of Mr. Bandyopadhyay, in as much as within the four corners of the instant writ petition, the writ petitioner has miserably failed to establish his independent right, title, or interest over the water body which belongs to the private respondent, where alleged filling is going on. Or how can I have an independent right, title, and interest? And the Honorable Court grants me a liberty to take recourse to public interest litigation.
Let us come to the other side. Let us go to the other side. Yes, Mr. Bandyopadhyay. How do you defend this?
Well, in my case is this, my lord, I have submitted before the learned court.
Whatever you have submitted, yes, we have seen.
My lord, the repetition is maintainable not before the single bench. The repetition are, my lord,
public interest litigation.
Interest litigation. And his lordship has, my lord, held that.
Held that, yes. Appropriate for.
That's the appropriate for.
And you, what do you?
Respect of, my lord, this petition, my lord, has annexed, my lord. Kindly come to, my lord, annexure, last annexure, that is, my lord, page.
Although you have taken step, my lord.
56.
The authority.
No, on merits, yes. On merits, if he wins, then we relegate it to the.
My point is that this is not meant before the.
That the writ court will have to hear if we at all allow his appeal. Subject to hearing.
Which was sought for before this honorable court, my lord. That was also sought for before the tribunal. My lord, kindly see the proceedings initiated by my learned friend in tribunal.
But that was not the ground on which it was rejected. The writ petition was rejected.
No,
This point was never canvassed.
That was not canvassed because factual aspect was not.
Well, not.
I am canvassing before your lordship in the first time. That is their document. They have annexed, my lord. My lord, these proceedings is going on, and the same prayer has been made. No. My lord, kindly see page 56 onwards. And
this is preemption.
Preemption.
Preemption proceeding, my lord.
Not related with this. This is not related with this.
May I just?
LR case has been filed, my lord, here. My lord,
so that is your point.
Here,
let us hear him.
The point is, one of the prayer is not to change the right title of the.
That's an ancillary prayer. Preemption in connection with the.
May I just indicate one thing, my lord?
You sought for a preemption that was sold.
That is not this plot of land. This for my lord, I have made that disclosure in my writ petition.
Different plot of land.
Different plot of land, my lord. That I have disclosed that in my writ petition because I came with clean hands, my lord. So I have.
The present challenge has been preferred against an order whereby the writ petition from which the appeal arises has been dismissed on the ground of maintainability, in view of the finding of the learned single judge that the writ petitioner stroke present appellant does not have locus standi to present the writ petition. For the next para, the brief facts of the case are that the private respondent, a neighbor of the appellant, allegedly is converting a water body. Full stop. The petitioner, the appellant, lodged a complaint with the appropriate authorities. Full stop. It is alleged in the writ petition that despite such complaint, appropriate measures have not been taken against the respondent in The latter apostrophe is attempts to unlawfully convert the water body and change its character. Full stop. Next para. The learned single judge, comma, while dismissing the writ petition, comma, was pleased to observe inter alia that the writ petitioner has miserably failed to establish his independent right, title, or interest over the water body, which belongs to the private respondent, where alleged illegal filling is going on, and granted liberty to the writ petitioner, comma, being a public spirited person, to approach the appropriate forum, comma, apparently indicating a public interest litigation. For the next para, learned counsel for the appellant places reliance on an unreported division bench judgment, an unreported coordinate bench judgment of this court in the matter of MAT 930 of 2024, bracket A, Messrs. Bangbhumi, BNG, BHUMI, Real Builders LLP, comma, where, comma, upon a detailed discussion of the law prevailing in the field, comma, it was held that a complainant in respect of an illegal construction was entitled to maintain a writ petition alleging of inaction on the part of the authorities with regard to such unlawful construction, comma, despite being merely a resident of the area. Full stop. Next para. Learned senior government, your senior AGP, your learned senior government advocate submits that the remedy of the writ petitioner lies before the appropriate division bench by way of a writ petition, by way of a public interest litigation at best. Full stop. Insofar as the present allegation is concerned, comma, the writ petitioner does not have locus standi to maintain the same. Full stop. Next para, learned counsel appearing for the private respondent points out that even as per the annexures annexures to the stay application to the present appeal, comma, a tribunal application is pending where a similar relief has been claimed by the respondent, by the present appellant. Full stop. As such, comma, it is submitted that the writ petitioner was not maintainable in any event. Full stop. Next para. Upon a careful consideration of the cited, the judgment cited by the appellant, comma, it is clear that the entire law in the field and the evolution of the law in respect of locus standi to maintain a writ petition was discussed by the coordinate bench. Full stop. Next para. It is well settled that the limited and restricted conspectus of locus standi has undergone a sea change by evolution of law, and in the event a person residing in the locality comes to know of an illegal activity having public ramification going on, comma, such person has the right to bring such illegality to the notice of the writ court and obtain a relief. Full stop. Next para. In the cited judgment, in the cited report, comma, it was inter alia discussed that the expression single inverted aggrieved person, inverted clause, denotes an elastic and an elusive concept. Full stop. It cannot be confined within the bounds of a rigid, comma, exact and comprehensive definition. Full stop. Its scope and meaning depends on diverse, comma, variable factors such as the content and intent of the statute of which the contravention is alleged, comma, the specific circumstances of the case, comma, the nature and extent of the complainant apostrophe's interest, and the nature and the extent of the prejudice or injury suffered by the complainant. Full stop. Next para. It was held by the coordinate bench further that since the writ petitioner therein was a resident of the concerned municipality, comma, which was an undisputed position, comma, he was entitled to raise a dispute regarding an unauthorized construction going on in the locality. Full stop. Next para. In the present case, comma, the learned single judge proceeded on the erroneous premise that the writ petitioner has miserably failed to establish his independent right, comma, title or interest over the water body which belongs to the private respondent where the alleged illegal filling is going on. Full stop. Next para. The relief claimed in a proceeding has to be tied up with the nature of rights which form the foundation of such reliefs. Full stop. Next para. The independent right, title or interest of the writ petitioner over the water body is not agitated in the writ petition. Full stop. It is not such right which has been claimed or sought to be vindicated before the writ court. Full stop. In any event, if the writ petitioner claimed such a right, it would have to be canvassed before a competent civil court having jurisdiction. Full stop. The relief sought in the writ petition is in respect of alleged illegal filling up of a water body by the private respondent. Full stop. The locus standi has to be linked to the cause of action. Full stop. The cause of action in respect of illegal conversion of a water body may or may not relate to the right, title, or interest of the complainant with regard to the land which is sought to be filled up. Full stop. What is to be seen is that the complainant resides in the vicinity of the premises where the illegal conversion is allegedly going on, and that even tangentially, the complainant would be affected directly or indirectly by such illegal filling up. Full stop. Next para. The illegal conversion of a water body into a different character would not only be restricted to violation of municipal laws or affectation of rights of particular individuals, but has much wider ramification in as much as the ecosystem of the entire locality would be adversely affected, which would have a ripple effect in the other neighborhoods in the vicinity as well. Full stop. Next para. As such, the cause of action of the writ petitioner need not necessarily be tied up with his right, title, or interest in the property in question, but in respect of the said larger ramification of the alleged act of the private respondent. Full stop. Viewed from such perspective, the restrictive view taken by the learned single judge is dehors the law and contrary to the well-settled principles of law as rightly discussed in the matter of Messrs. Bangabhumi Supra. Full stop. Insofar as the objection of the private respondent relating to a different tribunal application pending at the behest of the petitioner is concerned, the same is not germane, since the primary relief sought in the said application is in the context of a prayer for preemption under sections 8 and 9 of the West Bengal Land Reforms Act 1955, and the injunction sought in connection therewith is merely a consequential relief corollary to the primary relief. Full stop. Next para. Thus, the relief sought before the writ court in the present matter has not been sought before the tribunal. Full stop. Furthermore, as pointed out by the appellant, the subject property involved in the tribunal application is different from the property where the alleged conversion is going on. Full stop. Keeping in view the above perspectives, we find that the learned single judge erred in law in rejecting the writ petition at the threshold on the ground of maintainability. Full stop. Accordingly, MAT 1317 of 2025 along with CAN 1 of MAT 1317 of 2025 is allowed on contest, thereby setting aside the impugned order dated impugned judgment dated August 4, 2025, passed in WPA 15313 of 2025, and remanding the matter to the learned single judge having jurisdiction, remanding the writ petition to the learned single judge having jurisdiction to decide the same on merits in accordance with law. Full stop. Consequentially, CAN 1 of 2025 stands disposed of. there will be no arrest to cost. প্রথমেই affidavit of service filed today be kept under court.
But they are carrying on construction at a rapid scale.
It is made clear
They have
that
already
it
taken
will,
step, my lord.
it is made clear that it will be open to the writ petitioner to pray for appropriate ad interim reliefs before the learned writ court.
My lord, may I play one thing, my lord? We have not exchanged the affidavit, the allegations.
আচ্ছা,
made
fair.
by that.
Since we have not directed affidavits to be exchanged, comma, it is deemed that none of the allegations made in Can 1 of 2025 is admitted by any of the respondents.
So the government has already taken step, my lord. He has taken measure. The private has
We have
already-
kept that open, you take that open.
That is actually Pukur part.
Start.
Longish matter, longish matter.
Little facts are there. I can give the background. What is the case, ma'am?
Item 9, we'll see the name of your client, whether you should.
Name the
No, no, you don't get. So whether Pathard, he could afford a Pathard. It's not indicated. Let us see the occupation.
And my lord, lordship, the longest order.
Business, business.
Kindly give me 2 minutes time to indicate what is the matter about.
Or should you see whether there is any shorter matter?
Up to my.
In any event, you can start. Since you are here, no matter will be finished in 2 minutes.
What happened in this case, my lord?
We have 5-7 minutes.
Yes, yes. 5 minutes. I will give the background of the case. In Howrah, Andul, we purchased a property. Mutation done. Sanction plan obtained. Make construction after conversion. At
Obtaining permission to convert.
Everything. Everything. At that juncture, a complaint has been lodged by the private respondent and file a writ
আপনি
petition.
in person appear করছেন?
File a writ petition that this land belongs to the government vested land. So I have encroached on the vested land. Railway authority's land. The court relegated the matter to the central government.
It's happening for the railway authority.
Sir,
Railway authorities to decide the issue and pass an order. What the railway authority did, our specific case was that section 4 and section 6 was issued in respect of the entire plot of land 2195-2196. Entire plot, full F. But when possession was taken and the award was passed, 1 decimal each out of the 2 dag was awarded and taken possession. Am I clear to my lord? 4-6 full, but award passed 1 decimal each and possession taken 1 decimal each. So our case is we are not under the purview of the vesting. That order was passed, that order was challenged. The order was passed by the railway authority saying that this is our property, so it has to be ousted. I should be ousted. I have challenged that in a writ petition. In the writ petition, state government categorically said what I am saying before my lord, that 4-6 was a full, but possession was taken of 1 decimal each and award has been passed in respect of 1 decimal each. There was no pleading to that effect, but on the ground which my lord, he has been, at the time of hearing, it has been, one document has been handed over to the honorable.
What had you challenged in the writ petition?
The order passed by the railway authorities saying this is my property. In the pleading, I say in this court, pleading of the state, who is the my lord acquiring authority, he said no, his contention is correct. 1 decimal each from 2 dag has been taken, award has been passed. The hearing is going on. On the hearing, a document was produced before the court by the private respondent saying that this land was previously acquired by under the Defense of India Act, which is not nowhere on the 3 stage of proceeding. This was not there, never. And relying on that document, without having any opportunity to ask, the my lord, my writ petition has been dismissed with exemplary cost of 8 lakhs of rupees and directing the railway authorities to take steps in accordance with.
Mr. Mukherjee was there or you were also there?
I was also there.
What did you do?
But that's my lord, I was surprised. After the delivery of judgment, I was not there. I inquired from Mr. Mukherjee, which ground I was defeated. State government, they admitted the fact.
কিছু একটা গন্ডগোল পাচ্ছি।
He.
Cost, where is the cost mentioned? No cost were given.
Cost, yes. Cost
Where?
granted. 8 lakhs.
Where is that?
Last part.
Paragraph 49 or 48 is this disposed of.
এই তো দেখলাম কোথায় গেল ব্যাগ 42 32 yes 42 yes my lord 42
42 is the disposal. Where is the cost?
42
42 আছে
42
oh since very whistleblower 2 lakh oh 2 lakh to the private respondent
4 lakh to division with the salsa
remaining 4 lakh means total 6 lakh
yes it is to pay cost of is 2 lakhs to the private respondent number 14 within 15 working days today and the remaining
That is the price of the whistle. We'll have to look into this.
admittedly state government says I have not acquired
No, but Defense of India Act under that provision.
that is not pleading no pleading
Defense of India rules, my lord. 95.
Rules.
yes so this was never the case of
Railway
anybody.
also does not have a stake in it.
We have admitted
No, railway authorities.
railway authorities have said nothing
My lord, if your lordship comes to only paragraph 18.
Paragraph
18, my lord,
of the stay application.
of the stay application.
stay
Page 19, my lord.
Yes, 18.
May I place this, my lord?
Please. Oh. He has accepted. But then also you don't.
My lord, allow me to explain this, my lord. Now, the entire case has been curtailed to this, that since the railway is not the authority, railway should not pass the order. State should have passed the order of the demolition, my lord. Now, my humble submission with regard to this is, my lord, there was a PIL file before this court, my lord. Now, in terms of the order of the court, my lord, railway was directed to check whose land it is and take decisions accordingly. If there is any encroachment, railway will take the decisions. Now, my lord, the best part is, on today's date, my lord, that land has been in the railway's name. Now, good or bad, it is in the name of the railway. Now, it is the state authority who has transferred that land to the railways in 2022, my lord. They had knowledge of this in 2022. They did not challenge to this, my lord, that the railway, this name has been transferred to the railway. Thereafter, my lord, this order has been passed that we are to look after it, whether that there is any encroachment. There is no dispute with regard to 2 decimals. They have occupied 12 decimals. Even in the case, 2 decimals is of the railway. So I had the authority to pass this order, my lord. Now,
decimals you have the authority.
my lord.
What about the other rest?
My lord, that 10 decimal, it is the BLRO who has transferred it to the railway, my lord. It is on, because we did not have any documents and this encroachment was taking place. That is why a public interest litigation was filed. So it is the state authority who have come up and stated, my
But
lord.
BLRO doesn't have the authority to transfer it to you.
They had one inspection to LAO. According to that, in 2022, my lord, that particular 10 decimal, that is a big land, my lord, acres of land.
Yes, but somebody else's land cannot be given to the railways also.
My lord, in any case.
Point 2, if it was not acquired by the state or in any other statute,
my lord,
then it cannot be given to anybody,
lord,
including you.
My lord acquired. As because, my lord, that is a notification was also there. But
Notification there, but you took possession of, then regarding the rest, it should be deemed to have lapsed.
My lord, after that, my lord, one thing, my lord, that we have given that notification. That notification was not handed over to me by the authority, my lord. But after that, my lord, we can get that from the private respondent, we can get that. And that is, my lord, in erratum. Well, if your lordship will see, in our erratum, that is one correction. My lord, that was I canvassed in that ABDB in opposition, my lord. In
the errata, you have pointed out that the acquisition was in respect of the entire property.
No, erratum is a
errata.
Errata is only for the, my lord, 2 is already 1. First, my lord, 5 and 7, that is 12 shotaks was acquired, and that was done. Everything was done. 4, 6, and everything.
So you
was
supported their stand.
Yes, my lord. No, my lord. Their stand, they purchased 12 shotaks of land. But I say,
out of that, 2 shotaks have.
No, my lord. 5 and 7, that is 12 shotaks. Is already 4 and 6. that is completed, my lord. But at the time of award, my lord, we have done that only one Shatak, the 2 Shataks was award was passed. As an erratum there was there.
So if award was passed in respect of a limited portion 1, 2,
2 Shataks.
then it can only culminate in section 16
And
regarding that.
because, my lord, there is a erratum, that is correction, that previously that land was vested in.
Therefore, restrict your rights to this 1, 1, 2.
Yes, my lord. 1, 1, 2 and 10 Shataks was, my lord, and the erratum correction that it has already, my lord, vested, acquired by the act.
We'll
of-
continue with
Yes,
this
my lord.
tomorrow because we have a 3:30 today. Tomorrow you have difficulty.
Tomorrow is a
Tomorrow is
holiday,
Monday.
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 Tomorrow it will be difficult to
my
go.
lord, on Tuesday, my lord. If
Tuesday.
Tuesday I will not be here.
Wednesday, my lord, any day, because Monday I'm
Choose your dates. Whichever date we miss,
My
they
lord,
will have some
any day
difficulty.
after-
Not every day.
any day after Monday. my lord.
আমার কোনো date নেই।
So then Wednesday remains.
My lord,
আপনার কোনো অসুবিধা নেই তো Wednesday হলে?
আমার কোনো অসুবিধা নেই এবং আমি বাংলাতে বলতে চাই।
আমি তো বাংলাতেই জিজ্ঞেস করছি আপনাকে। তো very well.
But
We are not
cost
making
part-
it part-hard.
Cost part is calistic. Cost part.
On that day, my lord, your
Other there is a proceeding to.
কস্ট পার্টটা স্টে করছি কয়েকদিনের জন্য কারণ আমরা আজকে শুনতে পাচ্ছি না পুরো কস্ট যদি আগেই দিয়ে দেন তাহলে আর কিছু থাকবে না The present challenge has been preferred against an order whereby writ petition preferred by the present appellants was dismissed. Full stop. The premise of the appellant's case is that although notifications under sections 4 and 6 of the Land Acquisition Act 1894 were published in respect of certain plots of land, only a portion thereof was ultimately acquired by the state. Full stop. Next para, learned counsel for the state submits that by a subsequent erratum, ERRATUM, such clarification was made, whereas learned counsel for the railway authority submits that the state itself had transferred the entire property in favor of the railways. Full stop. Next para, the private respondent, with leave of court, appears in person and controverts the submissions made by the appellants. Full stop. However, due to paucity of time, the matter cannot be concluded today. Full stop. Accordingly, let the matter stand postponed till September 9, 2025, when it will be listed under the same heading. Full stop. The portion of the impugned order whereby costs were awarded against the appellants shall remain stayed till September 26, 2025 or until further order, whichever is earlier. But we'll take it up on 9 September.
9th I have said, my lord.
Oh, sorry. September 9 না, September 10. September 10, 2025 আর স্টেটে যা বললাম।
Before my lord rises, I'm sorry.